Good evening. Planning Board is now in session. We have the full board here tonight. It's been an active day. Hope everybody's doing well on this warm summer night. How many of us would really rather be somewhere else? Trevor, could you do a room shot? Just want to show everybody at home how many people we have here. Everybody can wave to the people at home. Here we go.
There you go.
So, what, the agenda item for tonight is a discussion. And when we have a discussion item listed on the agenda, it means that it's kind of an open thing where it's different than a public hearing or something that's really rigid. So we hope to have a discussion tonight. We also have our consultant with us. I'll get to that in a minute. Before we get to the discussion item, there's a few things I have to read. And want to make sure that when we do have the discussion that we stay professional and polite and, you know, not get personal, stick to the details, and try to have a good meeting about Park Central and these other, unless everyone's here for the solar bylaw rules, no? Yesterday, while the town planner and Hillary and myself were getting ready for tonight's meeting, there was some back and forth with town council, and it was learned that there was a scheduling error. Back on July 11th, we received from town council his legal opinion letter in response to our legal opinion request dated June 4th. So on July 11th, we received that. And if you remember, on July 18th, the planning board had a meeting. And during that meeting, we discussed the contents of the legal opinion response. And some of the board members asked if, or indicated that they wanted to ask some more questions and get some more clarification on the contents of town council's letter. So as a result of that, on the 18th, the night of Monday the 18th, midday on the 19th, when I was here in the planning office, I picked up my cell phone and with Hillary and Jyoti next to me called town council. And he graciously answered and told him what we were looking for as far as additional attendance by him to help the board understand, you know, his response. And so we compared the availability of planning board members to town council's availability, and we zeroed in on July 11th was the night that all five of us could be here, August 11th, and that town council would be available. But yesterday, town council indicated that he had a conflict, and that the conflict existed prior to my phone call on July 19th. How did this happen? He said that when I was on the phone with him on July 19th, that he looked at his, I guess he has a personal written calendar that he carries with him, and it showed that Thursday night was available. And I, you know, reminded him that Thursday night is a pretty off night for the planning board. We're usually Monday nights. But we would have this extra meeting to accommodate what we're, you know, trying to accomplish with the town council. He then explained that it was in his, that he was all set for August 15th, which is the continued public hearing, and when he checked this week his electronic calendar, it confirmed that he did have a conflict for tonight in another town. He didn't explain to me beyond that, but basically the bottom line is that he had a conflict and that he didn't connect the dots until yesterday. And so he sent this email this morning. Greetings, planning board members. Regrets for any inconvenience caused by our meeting conflict. I will be available for as long as needed Monday, August 15th, anytime commencing 5:30 p.m. on And I look forward to working with Judy Barrett, who's our consultant here at the end, on any procedure matters relative to the pending site plan review or Chapter 40B comments back to the newly reconstituted ZBA. Best, Aldo. So, we just, we posted the meeting, we found out about this yesterday, and Judy had this on her calendar to come, so we said, well, let's do the best we can with our 40B consultant. Judy is not a lawyer, but she has helped us over the years, many years, on our zoning issues and the zoning advisory committee. So she knows our code, and she knows many of the town officials, and she certainly has the flavor of the town of Southborough. Also on the table here, we received today from the town clerk's office, just after lunchtime, a zoning board of appeals revised meeting agenda for August 17th, 2016 at 7:30 p.m., and it's the continued public hearing. And it just lists, it says, Park Central Comprehensive Permit 40B, discussion of traffic and conditions of the decision. And the Park Central Comprehensive Permit filing extension deadline is August 31st. Other business before the board, discussion of reorganization of the board, other business properly before the board. So that was given to us by the town clerk's office. And then, so we're working our way toward Monday, which is the 15th, and today, Jyoti received a phone call, which was then followed up with this email from Mr. DePietri's attorney, Angelo Catanzaro. It's dated today, 3:16 p.m., and it's to the town planner. I copied Mr. DePietri and Dan Ruiz and town council Aldo. Jyoti, thank you for taking my call. This is to confirm that our engineers will not have final site plans completed until on or about Monday, August 15th. We will circulate same to the planning board immediately upon receipt. In view of this, the applicant does not have any additional substantive information to provide the board at the Monday, 8:15 scheduled hearing, and that's the date, not the time. As I understand that Park Central is on the agenda and that town council intends to be present, I will also appear, but I will not have our engineers present. As we discussed at Monday's hearing, I am going to request that the board, must be the planning board, schedule a special meeting for Park Central for August 29, 30, or 31. A meeting at that time would provide you and the board, oh, so the board must be the zoning board, with approximately 2 weeks to review the plans that you will get next week. The board's consideration of this request would be greatly appreciated. I understand that you will check with the members and let me know later this evening or tomorrow. A meeting can be scheduled for one of those dates. Please respond by email. If you need to speak with me, let me know in the email and I will promptly contact you. I shall look forward to hearing from you, and then it's signed Angelo Catanzaro. So, this was just this afternoon we received that. I forgot to, in this chronology, last Monday, on Monday the August 8th, the town planner sent a letter, which she coordinated with me, to Mr. DePietri's, to Capital Group, confirming that we had not received a revised plan. And that was August 8th, knowing that we have a continued public site plan hearing on the 15th, 7 days away. The letter essentially stated that, confirmed that we had not received the revised plan yet, and that, as they know, once we receive a revised plan, it gets distributed to other town departments, gets distributed to the board members, and to our consultant for review, and that 7 days from Monday is insufficient to really have any substantive review questions or comments, and therefore put the developer on notice that we would expect that the approval period, which is currently August 17th, 2 days after Monday, would need to be extended beyond the 17th. So this kind of follows along with that, proposing that we continue to August 29th, 30th, or 31st. I have not checked my own schedule as far as my availability, and I'll at some point ask the planning board to check on their availability. And then as a side comment, based on years of experience of summer meetings, we've stated over the years many times that, and asked proponents to be sure, if you're going to schedule a summer meeting, that you're going to be ready. Myself and a few other planning board members over the years have been, I'll just limit it to myself, stupid enough to change vacation plans to accommodate these meetings, despite saying, are you sure you're going to be ready? And here we go on August 15th, scheduled back on July 18th, and they're not ready. And I'm sure that other people have changed their plans to be here on August 15th. And based on what we're hearing tonight, there may be some substance to the meeting, but the developer may ask to simply continue to a future date and have no discussion. And the board would be free to do that, or free to continue to have some discussion on Monday. So I think that covers all of the paperwork, or some of the paperwork, that we received today. So the first agenda item is right here. Park Central Draft Environmental Impact Report and Legal Opinion. That's two separate documents. Here's the draft environmental impact report. If anybody wants to refer to it, it's here on the table. It consists of 10 sections, 11 sections. And Jyoti, we received, what did we receive back on that? Is that this right here? Tell us what that is.
We sent our comments in, can you hear me? We sent our comments into MIPA July 21st, I believe, and we still haven't received comments from MIPA back to us. But in the meantime, the proponent's consultant, Epsilon, responded to all the comments. So that's what this report is. And I got this from Beth, and I only have the response to our comments, but it's a very big document. It's like 200 pages, but that's what this is. I don't know if you want to go through this.
What's the date of it?
This is August 4th, 2016.
And when did we get it?
We printed it out yesterday. I'm not sure when it came by email to Beth. It came to, so probably around the 5th, maybe.
The 5th?
Yeah.
Might ask you to find out when that was distributed.
Okay. I'll check.
Yes, sir.
Request to correct Jyoti's comment that it responded to all.
All right, you're going to need a mic. I thought it was going to be a quick question.
Is this on? I would like to correct the record that Jyoti indicates they responded to all
You're right.
of the
They did.
respondents. That is not true. They specifically did not respond to a number of letters, mine included. I've made a note of that to the various boards, and I resubmitted my letter by the August 5th deadline, and still waiting for a constructive response that deals with facts.
I apologize. I meant they responded to the planning board's letter.
Yeah.
Sorry.
So,
I think.
yes, Mark. Microphone, please.
Mark Pasamato, Chair of Conservation Commission. Couple of points. One, the dates of 8, 29, 30, and 31, which Mr. Cartnazzo is asking for a meeting. The Conservation Commission has a scheduled meeting with them on the 31st. Not sure why he thinks that date would be open for them, but it's on our calendar as of our last meeting.
That's
So
good to know.
So that would reduce it to 2 dates.
Right, because we have, it's possible to have 2 boards meet at the same time, but we're highly advised to not do that.
I'm not sure we fit in the room. The second point, the response to the draft environmental report to MIPA. We received that, Conservation received that at about 12:40 on Thursday the 4th. Because our meeting was that evening. And the majority of the responses in there refer to the yet-to-be-received plans. Which part? The majority of the responses in there to the various items identified basically said, you'll see the item, resolved or taken care of or responded to in the plans that are being updated, which we're still waiting on.
Which we're still waiting on, yes.
Like, there's, a number of items, one after the other. So the content of it is rather light, yeah. Thank you.
So what I'd like to do is introduce Judy Barrett. And Judy, if you could just, I kind of gave an overview of how we know you, and what we did was, as many of you know, the planning board was trying to get some advice on how to proceed with the 40A and the 40B elements of, mostly the 40A element of the Park Central projects, and had asked the selectmen, in accordance with our code, for permission to get an independent counsel to advise and guide the planning board, and that request was denied. So at the end of, and the planning department had money this year. We've hired consultants for other aid and assistance. And the reason we had the money was because we didn't have a town planner since January, so a lot of that salary was available for hiring consultants. So in June, before the end of the fiscal year, we had a handful of contracts. We discussed them here in June at our public meetings. And one of them was to hire Judy's firm, who are not attorneys, but knowledgeable and authorized to speak relative to 40B and because she knows our zoning code and zoning throughout the state, we thought that Judy was an ideal person to help the board understand the actions and the procedural things that have happened over the last couple of years relative to the project and the actions of the ZBA. So tonight's our first night with Judy on this project, and I'd like to introduce her and ask you, Judy, to just tell us what company you work for and how you maybe plan to help us and reinforce the fact that you are not a lawyer. You have to press your, there you go.
Voila. Can you hear me? Okay. So I'm Judy Barrett. I'm with RKG Associates. We're an economic development and planning and real estate economics firm that will be based in Boston as of tomorrow. We're moving. It's been an interesting week. So it's part of why I don't have a lot of copies with me tonight, is that our equipment has been gradually getting shut down all week. I've been off and on with the town. I worked on the master plan with VHB several years ago. I had the privilege of working with zoning advisory committee for a while. Sam, who's here, was on that. Don was on that. It was a great group of people. the role I'm here now, I work for the same program that Ed Marchant, who also is not a lawyer. Ed Marchant and I both work on a consulting program that is funded by Mass Housing Partnership to help boards of appeal with comprehensive permits. I'm actually dealing with, I kid you not, 12 of them right now, and that's, it's a lot. But, so I'm very familiar with 40B, but I come at it from the perspective of a planner, and I just, in looking over the draft decision that I know you've received from the Board of Appeals, I think for comments, yes, there's a draft comprehensive permit decision that's out there.
Actually, I'll just inform that the first draft was last week,
Yeah.
and then, was it today?
The second draft.
Today, there's a second draft, so
Oh, okay.
if you're not aware, I believe on the top it says second draft.
Okay, I have the first draft here. So, I mean, one of the things, and without having seen the second draft, I can tell you, typically, I don't know, Sam, how you handled this when you were on the Board of Appeals, but the subsidizing agencies kind of ask DBAs now to sort of send a draft of the decision in so they can look at it, because there's nothing worse than sort of issuing one of these decisions and then having the subsidizing agency come back and say, well, we're not going to approve that. So there are things in the first draft that I think the subsidizing agency will have a problem with, and I think it would behoove the town to sort of find out now, before you go issue this decision, whether the subsidizing agency is going to be okay with it. There are a lot of things that have changed in the last few years. Things like what constitutes a local preference policy, who's included, who's not. There are much more stringent guidelines on that now than there were a few years ago, in part because of a fair housing case out of the state of Texas about 15 months ago, but also because HUD has issued new regulations under the Federal Fair Housing Act. So there's just things in here that I think you would want to get their subsidizing agencies' take on before this decision gets finalized. And, you know, I don't know, town council takes a look at these, but, you know, if someone appeals the decision, it would be nice if town council kind of saw the decision before it was issued. So I'm just thinking, I'm not advising the Board of Appeals in this case, I'm working with the planning board, but I would think that they would want town council to look at this, and I would think that they would probably want the subsidizing agency to look at it as well. So that's just one thing that crosses, you know, my mind. One thing I don't understand, because I'm really just sort of jumping into this, I think at the end of this process in a way, is although I know the use variance was not appealed, the use variance goes into effect when the comprehensive permit is issued, but what if the comprehensive permit is appealed? Does anyone know what the status then of all these documents is? I mean, Phil, you might know, you're an attorney.
The use variance says specifically that it is not effective until the comprehensive permit has been issued and all appeal periods
I've expired.
have run, so.
Is the neighborhood still working with Attorney Hill? No, okay.
Before we move on, your comments about making sure that town council reviews the draft decision. I'm, based on my discussions today with John Rooney, and he sent an email. He copied me on an email that I'm going to read. That's consistent with. We should be assured that will happen.
Yeah, I mean, I have a number of questions about the draft decision, but again, I'm looking at the first draft, not the second, so things may have changed in the second draft that.
Jyoti has gone through and compared the two, and there's, I think there's only 4 or 5 sentences that were.
Yeah.
Were either words or dates were added. And we wanted to make that clear tonight, too, that there is a second draft out there, and the difference between the two, she has that here, so anybody can look at it, but it's pretty minor between the first and the second. Selectman Rooney this afternoon at noontime sent an email to town council. I guess at the time he was typing the beginning, it was morning, but by the time he pressed the button, it was 12 p.m. So it says here, Aldo, good morning. The board has just received a document titled Second Draft Finding, I'll say, quote, Second Draft Findings and Decision of Comprehensive Permit, end quote, for the residents at Park Central. It is simply dated September, and then there's a little gap, 2016. As you know, I am unable to substantively comment on the project given my prior recusal. However, I do believe I have the ability to comment on the issue of process, and I offer the following for your consideration. Please note that I am speaking as an individual, as the board has not had an opportunity to discuss this issue on an agenda, given that it was received less than 1 hour ago. That said, I would be hard-pressed to believe that an objection to the process would be anything but universal in nature. It is my understanding that both the Planning Board and the Conservation Commission are in the midst of reviewing this project and intend to offer comments. Your prior efforts in making sure other town boards, committees, and commissions were involved in the process are well documented. To prepare a draft decision without the benefit of those comments is a stark breakdown in the overall process. Therefore, I would request that you immediately counsel the ZBA to make sure they receive the input from those other entities before putting pen to paper in a written decision. Please feel free to contact me at your earliest convenience. Thank you, JR. So we received that today. I talked to Mr. Rooney. He and I were on the phone a little bit today, and he stated that this was a public document and I could feel free to read it, which I just did. So that follows up on, I think, one of the things that you brought up,
Yeah.
Judy.
I mean, just so everybody knows, you know, it's not uncommon when a comprehensive permit gets to this point. For a Board of Appeals, somebody has to start somewhere with what the conditions will be. And so it's not uncommon for at least the conditions to be drafted, first draft, everybody's got a chance to comment on them. You know, and then get comments on those conditions, to get comments from the applicant, to get comments from abutters, to get comments from other boards. So the final conditions may be very different from what's in the first draft, but you have to start somewhere. And so typically that's where the focus is what the conditions are, because the applicant's concern is what the conditions are that they have to meet. The rest of the decision, you know, in the procedural history, you could crap about the project all you want and say all the bad things you want about the applicant, but in the end, what matters is, do I have a financeable project? So, and that's really determined by the conditions. So, you know, I'm assuming that they are going to accept comments on these conditions. And that, is the planning board desirous to submit comments to the Board of Appeals on the conditions?
I think,
And
correct me
and
if
by
I'm
when would
wrong,
you be doing that?
the answer is yes, but I think we're all just waiting for that revised set of plans.
I see. They have not been filed yet.
Well, the developer's attorney stated that they're to be expected some point next week. And we've, you know, at the beginning of the site plan, where I think we stated that we're really not going to spend a whole lot of time on a plan that we know is going to be revised.
Of course, right. Right. So is that meeting that is being discussed for the end of August almost like sort of a work session type meeting with the Board of Appeals and anybody else who's interested to talk about? What is that, what is the purpose of that meeting?
It would be the continuation of the site plan public hearing.
Or when you say the site plan, do you mean a site plan submitted pursuant to the use variance or the plan for the 40B? 40B site
No,
plan
the
is what you mean, yes?
No. The 40B is outside of the planning board's jurisdiction, but
I
the
understand, but typically,
40A, the plan that we have shows both projects so that we can see, and the neighborhood and the roads.
right,
But we're reviewing the site plan for the roads that feed the whole project and the 40A portion.
okay.
But there's also, you know, a sewage treatment facility, there's recreation components that, you know, that are as part of the whole plan. But
Okay.
we've, as you read in the use variance, it's, the use variance refers to the planning board's role as a residual site
Yes.
plan
Right.
review and limits the planning board's jurisdiction to sidewalks, lighting,
Yes,
landscaping, and parking.
okay.
And so, the planning board, because, and we've stated this several times, that we've never done a residual site plan review, and we can't find anywhere that such a thing exists. We intend to do a full site plan review and have our consultant, Fuss and O'Neill,
Right.
do it as if there was no use variance, as any other site plan. And once that review is done by the consultant and by the board, we'll get comments, and then we'll review those comments in the public hearing, and just like any other site plan, we would either deny the project or approve the site plan with conditions.
So I have two questions. Who is reviewing the site plan from a technical point of view for the Board of Appeals? Did they hire Fuss and O'Neill? Is anybody reviewing? They did. Okay, so the board does have the benefit of technical review, the Board of Appeals, from the same entity that the planning board would be using. Okay. My second question is, when is the Board of Appeals planning to act on the comprehensive permit?
I think everyone in this room has that question.
When is their continued hearing on the 40B?
It's, I read that earlier,
Okay,
it's August 17th.
see, I okay.
The
I
deadline
was
for
confusing these
approval-
dates.
The deadline for approval currently is August 31st. The ZBA met on the 8th of August and voted to continue the public hearing to August 17th.
So they have 40 days from, if they close the hearing on August 17th, they have 40 days from August 17th to take final action.
But as I read the note from Mr. Rooney to town council to please advise the ZBA not to take that vote until comments are received.
I understand.
And
Right.
A lot of moving parts, Judy.
This is a
and
very unusual permitting process. I'll just leave it at that.
I believe.
Very
Attorney-
creative use of two statutes.
And I believe Attorney Catanzaro requested at the last ZBA meeting, correct me if I'm wrong, Jesse. I said, I believe Attorney Catanzaro at the last ZBA meeting requested or proposed, stated that, you know, the ZBA could make a decision and then wait for other boards and everyone to comment as a condition later. So I got the impression, me personally, not having spoken to the attorney specifically, that they were looking for a decision by the end of the month. Sorry, we keep hearing you. That they wanted a decision by the end of the month. End of the month. Is what I interpreted that to be.
Well, having the board vote a decision and having the board file a decision with the town clerk are not exactly the same. Are they looking for the Board of Appeals to close the public hearing and vote? Or are they looking to have the written decision filed with the town clerk?
I don't believe they got to that specific,
Okay.
but they were looking for a decision. Jesse, was that, do you recall too? Am I off the?
No, I think you're on target with that, Andrew. But yeah, I do agree that they did not specifically get into filing in their discussion.
Is the Board of Appeals looking for comments on this written draft of the 40B decision?
I don't think we've received a formal request for comments, but throughout the last couple of years, every time there's a document that the planning board maybe never got or got but didn't comment on, it came back to say, well, the planning board never commented on it.
Okay.
So,
But you were sent this, were you sent this by the Board of Appeals? I mean, did they send this decision to you?
Yes,
Okay.
draft came from there.
So I would interpret that as a request for comments.
and at the last CBA meeting, the new chair said that, as far as he was concerned, that all waivers that were already granted could be rescinded based off of feedback from other boards
Okay.
and committees. committees.
Would the planning board like assistance in preparing comments on this draft? Mr. Chair, do you want assistance preparing comments on this draft? Understanding that this is the first and you actually have a second over there, which I have not reviewed.
Let's start with Mrs. Luttrell. Would the planning, what's your opinion relative to assistance in commenting on the
Somebody's got a
second
comment.
draft?
I would say yes.
Mr. Stein?
Yes.
Mr. Jenks?
Yes.
Yes.
Mr. Mills?
Yes.
It's 5 yeses.
I am actually working in another community on the 17th, but I can have a memo to the board prior to that meeting on the 17th, the Board of Appeals meeting on the 17th. I can do that. I
Excellent.
just think there are some issues here that you might want to raise. Separate from the plan that I know you don't have yet, but just text here, there are some issues in this decision that I think you're going to want to address.
And that's great. That's why if those comments help make the decision a better one, that's the reason that we have you here. One of the reasons, the main reason is to help us understand what's going on. So,
It's perplexing indeed.
Judy, did you want to make any more comments, or I was going to open it up to the planning board if they had any questions or comments right now, or I was just going to open it up to the public?
Oh, I think we should open up to the public. I mean, I without the plan, you know, without town council here, I'm not quite sure how to help you tonight, so maybe if you have a discussion with the interested parties, I can help with that.
Yeah, you know, again, the agenda item refers to the draft environmental impact report, which has multiple sections.
Yes.
And it also, the agenda item also talks about the town council's review, which referred to several cases, court cases, that seem to reinforce the actions of the ZBA and clear up doubts and questions that the planning board has had for a long time. So that's kind of the framework of tonight's discussion. And so does anyone on the board want to speak, or should we open it up?
Do you want any comments at all on that whole issue about the board's CBA's jurisdiction, or are you satisfied at this point?
Let's open it up to the public and see where
Fine.
that takes us.
Sure.
Who wants to go first? With the microphone.
Hi, Marnie Houlihan, 26 Clifford Road. So I just have a very quick question around jurisdiction of scenic roadways in Southborough. As I understand, Flag Road, which is becoming a major topic of an egress for this Park Central, will be a major environmental, safe, challenging road to deal with. So it is under my impression, reading Mass law, that scenic roads fall under your jurisdiction. And so I just would like you to comment on that and how that jurisdiction falls into the framework of the egress and the secondary egress of using Flag Road.
Has
And-
the applicant requested a waiver from the planning board's scenic roads regulations?
No. Do you have the statute or the regulations?
Not with me, no, I'm sorry.
The
I'll
applicant,
say something, and then, based on my experience, and then you can clean it up. It's been, when I first got on the board, we had a lot of tree hearings and stone wall hearings for the removal of trees here, there, and everywhere around town. And the process was the planning board had a vote, and the tree warden had a vote. And sometimes the hearings involved a neighbor saying that the tree in front of my house is, I can't see around it, it's a hazard, I can't back out of my driveway, I want to cut down. And somebody, the public safety people would look at it, tree warden would look at it, planning board members would look at it, and a vote would be taken. We had one situation where it was determined that the homeowner prevailed, the tree was cut down, and then the homeowner was later seen using the space where the tree used to be to access his mailbox with his car rather than walking to the mailbox. The tree was in the way of his car getting to the mailbox. That was kind of a sad situation. We've had other situations where the vote did not prevail and the tree remained. And we've had other situations where trees have come down with no hearing at all. And we've asked, why? Why was that tree cut down? And I believe it's in the statute, and Al, you showed me that the other day, but I believe it's in there that states that if the tree is determined by the tree warden to be diseased, dead, or a hazard, then no hearing is required and the tree can come down. And for many years, we went with no tree hearings in front of the planning board relative to removal of public trees. And I believe during that time frame, there's been at least 100 and maybe 200 trees removed throughout the town. And many of them were diseased or kind of like falling down. And, but there was a time frame there where there was no hearings and the trees were coming down. So as it relates to Flag Road, I'm not sure, but if somebody determines that the tree, perfectly healthy tree, is a hazard because it happens to be too close to the road to allow cars to pass or to allow cars to go 40 or 50 miles an hour, then it could be determined without a hearing that the tree's a hazard and it could come down. I hope that doesn't happen. I'll turn it over to Judy if I'm out of bounds on that, but that's been my experience.
It's a very interesting interpretation of the statute. Typically, what I've seen in other communities is that in a town that has adopted the Scenic Roads Act, any proposed removal of a tree or stone wall within the public right-of-way is subject to a hearing by the planning board unless there is an imminent hazard associated with the tree, not for the proposed change, but just simply because the tree itself, where it is now, is a safety hazard. My concern is simply that the applicant has a responsibility to ask the Board of Appeals for all waivers necessary to construct their project. So if they haven't asked for a waiver from the Scenic Roads Act, I don't know quite how they construct their project without coming back to the planning board. I mean, there's not a blanket waiver under Chapter 40B. The applicant has to ask for the waivers that they need to build their project. So someone probably should look at the application and determine whether they've actually requested all the waivers that they need.
So are you saying that the ZBA has the authority to waive the
Absolutely, sure.
Scenic Road Act?
Yeah, because it's, what you're waiving is the local regulations, the local bylaw. You can't waive the act, you're waiving the local bylaw. It's just like with a historic district commission. If you had a historic district under Chapter 40C, but you have a local bylaw that's establishing the district, the Board of Appeals can waive the requirements of the Historic District Commission. They can waive the requirements of the Conservation Commission under your local wetlands bylaw. They can waive the Planning Board's regulations under the Scenic Roads Act. That's really indisputable, in my opinion.
You, I assume, are talking about for the 40B.
Yes, I am. Yes. That's part of what is unique about this situation, is that the 40B portion of the project that's subject to Chapter 40B, the Board of Appeals has authority to essentially sit as other boards for purposes of their local regulations. The reach of Chapter 40A for the use variance is different.
Mr. Chair, can I just read in MGL Chapter 40, Section 15C, pertinent to this discussion? This has just been handed to me. After a road has been designated as a scenic road, any repair, maintenance, reconstruction, or paving work done with respect thereto shall not involve or include the cutting or removal of trees or the tearing down or destruction of stone walls or portions thereof, except with the prior written consent of the planning board And then it goes on if there is no planning board.
Right.
And after a public hearing, duly advertised twice in a newspaper of general circulation in the area as to time, date, place, and purpose. So it is very explicit that you have jurisdiction over this flag road, and so I'd like the planning board to make sure that you keep this in the back of your mind as you proceed through these hearings.
All I'm saying is that for purposes of 40B, if the applicant requested a waiver from the planning board procedure, the Board of Appeals would have the authority to grant that waiver for the purposes of the Chapter 40B component.
And for in this current construction, if it is a 40B comprehensive permit, there's no way to restrict traffic from 40A portion versus the 40B. So if you approve that, all of that traffic would be coming out onto Flag Road.
You know, I am not an attorney, and I'm just telling you that every time I listen to, the more I hear about this project, the more it just makes my head spin, and I'm sure you're all feeling the same way. But I just think you need to be careful not to conflate the authority of one with the other. The Chapter 40B has a very specific purpose. It's to promote the construction of lower moderate income housing, and toward that end, the Board of Appeals has a kind of unique role, and its role is to be the unified permitting authority, if you will, for all the boards that have local jurisdiction. Chapter 40A is a different creature. It's zoning. So when a Board of Appeals acts under the confines of the Zoning Act and grants a use variance, its authority to vary conditions is zoning related. It's, you know, you don't have the same blanket to waive non-zoning requirements under a use variance that you have under a comprehensive permit. It's totally different statutory authority. I mean, again, I'm not an attorney. The town council needs, if he hasn't already done so, and I'm sure he will, you know, I just think it's a very specific question that really needs to be addressed. And, you know, to your point, if the construction of the 40A piece of the project involves disturbance that's subject to the Scenic Roads Act, I don't see how the planning board's jurisdiction can be waived under the use variance. But if you were, take the 40A out of the picture, if you were just building a 40 comprehensive permit, then the applicant would have the ability to request that waiver, and the Board of Appeals would be able to grant it. It just gets muddy here because you have these two sources of, they're not one and the same. That's the problem. I know, but they're not one and the same.
One at a time, we want
They are not one
to
and
let
the
it flow,
same.
but one at a
They're
time.
very different, and their purposes are very different.
Yes, sir.
Hi, Dave Schwartz, 55 Flag Road. To your point, Judith, and specifically the unique nature of this and how muddy or murky this might be, I'd like to enter the following. In regard to the legal opinion, the 5-page document that was posted, and the use of 40B to grant above-mentioned variances, the variances that have, for which a decision has been made, it is clear from the filing of the proponent that the project immutably incorporates both 40B and 40A components.
Yep.
They are intertwined in the strict sense that fully engineered site plans comprised in a comprehensive permit are being provided for approval, which require both uses at the outset. On page 4, it states, quote unquote, composite plans are necessary as road and building layout and footprints are an integral facet of stormwater drainage and utility locations. Further, the relief that was sought that allows for the residential development on the industrially park zone district and the spilling of an unspecified future development of 9 acres onto John Bolin Road onto Flag Road makes this a 40A site, and as much as the zoning board would advocate and use its legal opinion that this is 40B and therefore allows for the expedited, streamlined, and priority rights and approval of site plans, it is this movement's motion and petition that any such authority of ZBA for this project be completely curtailed, and that the planning board and other boards be given authorities that they have for full site approval as in any project of this impact and comprising this configuration of not only residential housing, but also unknown site developments whose impact should only come under standard operating procedures of zoning for the town, including referendums when and where suitable to allow for residents to participate in those approvals.
Sir, what are you reading from, just so I'm clear?
I'm reading from me.
Oh, I'm sorry, I thought you were reading from a legal opinion from counsel or something.
Anyone else? Yes, ma'am. This is, this is free-flowing and friendly, so feel free to, speak, just like we're neighbors.
We are neighbors. Jan Sussman, One Flag Road. I'm going to speak as an observer. I've been to 3 meetings in the past 2 weeks, and I think the thing that's coming in my mind is I feel like there's a lot of different fragments out there operating under different auspices,
Yeah.
but there's no one person or group of people, maybe a representative from each board, acting as an overseer of this project. So I feel like if you don't have a legal degree, financial degree, a building permit or a degree, it's very, very confusing. And for the common folk, I'm going to call us, who live as a taxpayer in this town, I can't help but think this has just spun out of control in terms of getting the proper information to the people that need it in a timely manner, and somehow outlining on a timeline where we are, what's happening. I feel like it's muddled, and I feel like that's adding to people's fury, if you want to call it, frustration. And if the town has never really embarked on something this large, is kind of what I think I heard earlier this evening, why didn't the town get a plan together as it was coming up as to how to coordinate efforts amongst entities that have the power to make these decisions? And that's the biggest concern that I can say I have right now at this point in time, having only attended 3 meetings. I feel like I'm coming in the 8th inning, and we've got a big decision coming up very soon. And I also would like to say that I agree that the summertime is a horrible time for planning meetings, because I'm not sure you're going to get full representation when you need it from your concerned citizens in the abutting areas, because, as you know, people plan vacations 6, 10, 12 months in advance. So those are the concerns I'd like to express tonight. I would highly recommend in the future, if a project of this magnitude comes up again, that the town really take a look at how to have the boards work together in a more cohesive fashion to get information out to the public and to make decisions in what I would say a more educated, knowledgeable way. So that's what I have to say tonight. Second time in front of the mic.
That's a good point.
Thank you. Sam, I'm going to call on you. The ZBA policy that, while you were on the board, I think goes directly to what Janet just said. Could you speak to that?
Sorry, I was actually doing something else.
Okay. You were one of the authors of a ZBA policy that addressed the concerns that were just talked about, which is having members of all of the different departments, town officials, form a group and work on this together, essentially. And I believe that there's a ZBA policy document that says that the ZBA, doesn't say it shall, it said it should form
Right.
this. Could you speak to that?
Sure. Sam Stivers, 7 Presidential Drive, a former zoning board member and chairman, member of the advisory committee, but speaking as an individual citizen about this point. I actually was the one who developed the ZBA's 40B regulations that mostly are still in effect. I actually looked at them the other day. They appear to be the same ones that I'd worked on a number of years ago. But the intent was for the various permitting boards, as the ZBA was standing in the shoes of other town permitting boards for 40B. The intent of the original legislation for 40B, as we understood it, was that everybody actually worked together to get all of those inputs in a comprehensive way that would allow for an expedited process, as DHCD required a very tight timeline for decisions on that. So at least at the time that I was on the board, we felt that it was important for all the boards to work together collaboratively and actively to make sure that all the right inputs were gathered and the final decision represented the professional expertise, if you will, of the various boards, particularly planning, conservation, Board of Health, et cetera, to make sure we didn't overlook any things. And so that was the intent, and that was my experience with a couple of projects, at least that I'd worked on, to, again, solicit input. There are requirements for sharing information in those regulations. It's not clear to me that the ZBA has actually followed those regulations that they're supposedly obligated to follow as far as this particular process is concerned. I haven't heard people talk about that, but I think if you look closely at those regulations, you'll find that they have not, at least in my opinion, followed the regulations as they were supposed to have done to date in this process relative to work with other boards and some other things in there. So sadly, I agree with Ms. Barrett that this seems to be a very confused process at this point, and clearly I think needs to have some close examination by town council or other legal experts to figure out where we are now with the process. At the meeting of the ZBA recently, I heard the statement that in fact there's a theory that the hearing process has actually closed because of a failure of the ZBA to continue hearings
To a time
properly.
certain.
And so, I've not looked at that data myself, but I have reasonable confidence that there are some strange things there, and I think it's certainly worth looking at. So, lots of questions, relatively few answers, and I think that leaves us with, as folks are talking about here, great confusion about the process. Unfortunate that it's happening during August when a lot of people aren't around. So, who knows where it goes from here, but I don't think it's working like the intent was when the original 40B regulations were written for the zoning board, my personal opinion. Thanks.
To your point, this is that's okay, and thank you, Sam, because I think that, as your board did, when it's a comprehensive permit, the Board of Appeals has this unique and pretty comprehensive authority. And it can work well when the Board of Appeals says, you know what, we don't do comprehensive permits all the time. And so we're going to go get the planning board involved. We're going to get the Conservation Commission involved. We're going to get everybody's input. There's nothing that makes a Board of Appeals do that. There is a requirement in the statute that when a comprehensive permit application comes in, it must be distributed to all the town departments and so forth within 7 days of receipt. So that's supposed to happen. That's a procedural thing. But that's not the same as let's all get together and work together. There's nothing that compels the board beyond sending the stuff out within 7 days. There's nothing that compels them to work with everybody. That sort of takes kind of an esprit, a sense of we're all like part of one community. Because you're a small town, you have a lot of elected boards, you have a lot of appointed boards, and everybody has their sort of, I don't want to call it a silo, but it sort of feels that way sometimes. I'm sure to Joe Public, it's like people are all in their silos and they don't communicate. But it is a small town, and that's fairly common in New England. So it takes the will of a board to say, well, we're going to get beyond that, and we're going to get beyond our little box, and we're going to reach out and talk to other people to make sure we get everybody's input. That's how you make that happen. And I think that is what you tried to do when you were on the board anyway, in just trying to get everybody's input. That makes a better permit, frankly. And it isn't that everybody's happy in the end, Neighbors won't be necessarily happy. They won't get everything they want. The planning board isn't necessarily going to get everything it wants. So everybody gets with everything they want, but at least the deliberation benefits from the expertise of boards that kind of do certain things all the time. And I don't want to cast aspersions on the ZBA. I just walked in here tonight after not having been in this town for a couple of years. But it just is a very unusual situation that you're in here, and somebody does sort of need to almost pick this apart and say, well, how do we put this together in a way that people at least have comfort that their government has operated in a competent and responsive way? don't know how else to word it.
Yes, ma'am.
Karen Shimkus, Limbrick Road. I've spent the last 25 years of my career evaluating large commercial real estate projects statewide and some nationally, some internationally, including access, zoning, massing, density. Any rate, I realize this isn't really a hearing, but it's just much easier to just read into the record. And also, before that, I'd like to preface my remarks with a concern on process as well, that it's just so disjointed and disconnected, and it leaves just so many inconsistencies that it's problematic. Also, I have a question, and I'm wondering if that second draft can be posted on the town website along with all the other public documents.
I can find out from the ZBA.
Thank you. And then also, I'd like to stress the importance that any conditions that are discussed by residents, including myself, definitely does not imply agreement or consent in any way to this 40B. I think it's perfectly legitimate that it be denied completely on the basis of safety. But I recognize that there may need to be some discussion on conditions, namely Flag Road, and the inclusion of Flag Road into any draft decision. August 9th, 2016, Southborough Board of Selectmen, Planning Board, Board of Appeals, MHFA, regarding Park Central, to whom it may concern. Please incorporate this letter as part of the record in consideration of the above-named project. As requested, attached is the Mass DOT memorandum dated February 19th, 2016. At last night's ZBA meeting, the ZBA members, Mr. DePranos, Mr. Eagle, and Mr. Bartolini, expressed unfamiliarity with this memo and requested a copy of it. This is a bit disconcerting because the memo is part of the DEIR, the Draft Environmental Impact Report. I hope you find this information helpful. Thank you. So I just supplied another copy, I guess, of a memo from Mass DOT dated February 19th, 2016, which is not all that long ago, which states, under Route 9 Park Central Drive intersection, this intersection is expected to experience poor levels of service with and without additional traffic related to traffic at this location. August 11th, 2016, Southborough Board of Selectmen, Planning Board, Zoning Board of Appeals, MHFA, Park Central, to whom it may concern. Please incorporate this letter as part of the record in consideration of the above-named project. BOS, please attach this letter to your response and communications with local and state entities, including MEPA and Mass DOT. I am wondering if the use variance has expired. Southborough Board of Appeals decision dated May 27th, 2015, relative to petition of applicant in Park Central LLC for a use variance filed with the clerk on June 11th, 2015. Please note that per Mass General Law, Chapter 40A, Section 10, the key part reads as follows. If the rights authorized by the variance are not exercised within 1 year of the date of grant of such variance, such rights shall lapse. And, provided, however, that the permit granting authority, in its discretion and upon application by the grantee of such rights, may extend the time for exercise of such rights for a period not to exceed 6 months. And provided further, that the application for such an extension is filed with such permit granting authority prior to the expiration of such 1 year period. Prior to the expiration of such 1 year period. It's Mass law. Therefore, I'm wondering if the use variance has expired in accordance with Mass General Law, Chapter 48, Section 10. I would appreciate a response at your earliest convenience. I hope you find this information helpful. Thank you. I realize that there may be some language written into the use variance that arbitrarily tries to extend that, but it's just doesn't match the law. The law is the law. Southborough Board of Selectmen, Southborough Planning Board, Southborough Zoning Board of Appeals, MHFA, Mass DOT, Ms. Carolyn Dykema, regarding Park Central, to whom it may concern. Please incorporate this letter as part of the record and consideration of the above-named project. Please attach this letter to your response to local and state entities, including MEPA and Mass DOT. Please see the following. Park Central Peer Review Traffic Study 2016. Park Central Peer Review Traffic Study 2016, posted on current projects and applications before the Planning Board. And I've given the citation to the link. This is the latest peer review listed by the town, and importantly, please see the following excerpt from page 3 under site plans that started on page 2. The key part of the Greenman Petterman Inc. report states that the following, referring to Flag Road. GPI recommends this connection be closed or gated for emergency egress only. This appears to mean that GPI is recommending right turn only or gated emergency left turn from access road onto Flag. That's a question. But importantly, it should be noted that this peer review study does not seem to be referenced in the draft environmental impact report. The latest traffic study, peer review, doesn't seem to be in the DEIR. Who is checking this? I would appreciate a response at your earliest convenience. I hope you find this information helpful. Thank you. Nope. No responses yet. But I'd be fascinated to hear one. If any of you have a response to... I'm sorry? Well, traffic peer reviews not in the DEIR. Why?
Mimi?
I think the DEIR is written by the proponent, and
Right.
so they write it in their favor.
Okay. Well, everybody's getting a copy now. Use variance expiring. If town council were here, he might be able to explain that, but I'd suggest that frankly, if there's frustration with regard to getting opinions that are really vital in terms of responding to things in a timely manner, as all parties are trying to, you may need other counsel to advise on that. I mean, these are very basic questions, and I'm surprised they're not being brought up. I mean, why are we bringing it up? I don't know. But, we certainly read everything, and we've read all 1,054 pages of that report, believe me, as well as everything else. Very, very frustrated with the way this process has gone. The use variance itself, how odd. Doesn't that strike anyone as odd how that got done? Written by the developer's attorney, put through at 10 o'clock at night after the public had gone home.
Well, frankly, what I find the most odd about it is that no one appealed it.
Yeah, I don't think they knew, because there's been a terrible gap in the way communications with the town, and particularly the most affected streets, have been, the way that it has transpired. We've actually had to put flyers in people's mailboxes in order to alert them even what was even happening about the project itself.
Are you saying that no one received notice of the variance decision?
No notice.
Well, that's my question. The abutters, I mean, the people who are legally entitled to notice of the decision, did they get it?
There are probably 25 abutters. There are many abutters, and
Well, abutter as defined in the zoning act is what I'm saying. I mean, are
No.
you all legal abutter? I don't know who you are, so I'm just asking a question. Did you get a notice of the hearing? I don't know. I mean, the assessors provide the list. I'm not gonna say
Well,
who's an abutter,
just
who's
for your
not, but-
information, there are many, many abutters.
Mhm.
And that's part of the problem, is the applicant went ahead and proceeded with getting agreement with a small fraction of the abutters, then came back to the town, and the town, for lack of a better word, just thought it was some broad-based
I
agreement
see.
with the neighborhood, absolutely not in capital letters. Absolutely not. And all the aggrieved parties on the affected streets, namely, Flag Road, of course, Deerfoot, Lover's Lane and Lindbergh, not included in any study. Those are one-lane winding country roads that accommodate one car. Now, why weren't those included in any scope of any traffic report? Because it wasn't going to produce the answer they were looking for. That's why. Because going down it in snow conditions, you can barely get one car down there. I've had to back up into people's driveways if you have someone coming at you in the other direction. And large commercial vehicles, again, one at a time. That's also true for Flag Road. There are points that only accommodate one car at a time. And you're looking at a photo right there of one. So, it's been a very unusual process, to say the least.
I think so.
So I hate to say this, but, I've worked on projects, a lot of projects, and I have to say, I've never been more embarrassed to review a project that is, for lack of a better term, I had an attorney describe it to me as it's always been a stupid location for a 40B, always, which is why Mr. Flatley never ended up developing it, because of the access problems and also because of the water. There's a huge gap in information with regard to water and infrastructure that, God damn it, the taxpayers better not be footing the bill for any infrastructure with regard to water. That would be absolutely an affront. But again, going back to access and water, the proponent has neither, and I just frankly don't see why the taxpayer is obligated to give either or any concessions on either. It's not our fault that he went and purchased a parcel that didn't have good access and doesn't have infrastructure. The adequacy of water is a huge issue. Are you watering your lawn right now? Or your flowers? Okay? I've seen no proof or evidence anywhere, including in the DEIR, that there's any adequacy. You have to have evidence of this. That's a huge, dense project. I haven't seen any evidence that there's adequate, water infrastructure or supply or how that's planned for. So I'm curious. I just need to know, why aren't you asking these questions?
The planning department received a copy of a consultant's water report. I believe it was this week. The town planner just went to get it.
I think John Green can speak to that. Thank you.
Thank you, Karen, and thank you for all your work on digging some of these things up. John Green, 10 Tower Road. I too have been kind of part of this project from the beginning, or at least following the project from the beginning, and can't say how disappointed I am in the way the town has handled it to date, especially around the ZBA, Board of Selectmen. I feel that everything has been kind of pushed through, has been disregarded as part of the overall process for the citizens to be able to make comments or be heard. We've been saying the same things over and over again. We've been submitting the same documents over and over again, and it seems as though the ZBA's never read them, never taken any thought into them, never brought up any objections, whether it be around safety, it be around density. And the point I want to make now, because Karen brought it up, is water. Back in March, I brought up the point about the water quantity issue within the Blackthorn Tower Road area, especially at the top of the hill. So if you know the two areas, the streets kind of go in a circle as they go up the hill. The water pressure is substandard as you get up to the top. Most of the citizens are required, or not required, but have to have pumps within their house to get adequate water pressure to take a shower, to use the faucet, any of those types of things. I actually had my house tested out in front. It's under what is considered standard, right? So standard for any new project would be 35 PSI, right? Out in front at the fire hydrant, I think is somewhere around 31. As you get up the hill, it moves into the 20s. The project itself, so when I asked that question, I had written to Karen Galligan, I believe is the name correct, Karen Galligan, DPW, as well as to the Board of Selectmen, asking for information around the water quantity for the project, how that was going to impact the neighborhood, and also for emergency, right? Because I didn't understand how the fire water system worked. I guess it's on a separate loop, right? So it's a little bit different than how it's provided to residents, is how it was explained to me. I was told in March that all of this was all set. A town engineer had already taken a look at it, and I was not to worry. Of course, me being me, I asked for documentation around it. No documentation came. Asked again, no documentation. Asked again, no documentation. Finally, at the Board of Selectmen meeting last week, I again asked for documentation from Mrs. Faniff, and she had promised me that Mr. Purple would send it to me. This information obviously came after the DEIR was submitted, or any of the information was submitted. I think that might have been a little bit too convenient for me to stomach with a lot of the things that have been happening. And the report actually reads, as the town planner is going to bring it in, that let me back up. I was also told that the neighborhood wouldn't qualify for any sort of pumps because Southborough is a gravity-only system. So does anybody on the board understand or know of any pumps within town that is improving water pressure at any locations? Yes. You do? Yeah. Where are they located?
It's right here, Phil, it's the Bolin pumping
Yeah,
station.
the Bolin Station, and I think there are two.
Well, I don't mean for the proposed project. I'm talking
No,
about
these are
in town. Existing?
Yeah.
Okay. Where are they
I
located?
believe that's correct.
Okay.
I don't know the locations. Johnson Road? Oh, at the bend, yeah.
So why do you think it would be that knowing that there's insufficient water at the top of the hill there, that they wouldn't be mitigating it?
You're asking the wrong person about
Right.
water systems.
Okay. So that went out to Karen. Karen told me that we were a gravity-only system and that they would not consider upgrading the system for anybody. So I was kind of confused to see that the first simulation that they did was actually in May or June. You can correct me because you're looking at it. So when I was told in March, this actually was never taken care of, right? There was no documentation. It was more of a, John, it's fine, it's all set. Don't worry about it, right? Which seems to be a theme around here with pretty much everything that we bring up. And the first simulation showed that the water pressure for the new project would be somewhere in the 20s. Has to be 35. So they are now having to put pumps in to mitigate for the development. But are, again, not fixing any of the issues within the neighborhood or mitigating anything within the neighborhood. So that's what that report is basically reading. And correct me if I'm wrong, because I'm not reading it, but. And in how this doesn't get discussed before now, where the applicant is asking for a decision in 2 weeks, is also a little bit strange. I have more things on other topics, but I'll let you guys comment on that.
So is this water on, this is to the Southborough Board of Selectmen, so it must be on the website. It's from the DPW. It's dated July 22nd, and it attaches revised water system hydraulic evaluation, proposed Park Central, and it's from Pear Corporation, P-A-R-E. Engineers, scientists, planners, clarecorp.com, stated June 28th, and it was sent to the selectmen on July 22nd. And we received it. I think you emailed it to us,
Yeah.
yeah, this week, because I read this,
August 10th, I believe.
I guess I read this
John?
yesterday.
Yeah.
Email here that comments on, yeah, definitely, for the record.
Karen's nice enough to cover me. She knows I'm not as organized as she is. So I wrote back a few comments when I got the email from Mr. Purple. CC'd on this was Mr. Rooney, Kalenda, Mrs. Fanoff, Shea, Semino, Karen Galligan, Ms. Dykma, Karen Finelli, and Mr. Morris. So for the record, thank you, Mr. Purple. I have a lot to say about this report, and we'll prepare my comments for the next meeting. A few key points. Why was this withheld from me until after the DEIR report was due? I asked for this back in March and 3 times since then in meetings and via email, and Karen told me it was done and all set in March with no proof as requested. The study is from June 2016, so it obviously was not done at that time. I was told when I approached Karen, RE, the water pressure in the neighborhood, that Southborough is a gravity-only system and that we do not allow pumps. This is why the town was unwilling to mitigate the issue at the top of Tara and Bantry Road. This is obviously not true again. Where in town are there other pumps? Question mark. Is this another unprecedented situation that we are providing to a developer? Why is none of the mitigation money going towards fixing the issue in the neighborhood? Number 3, the report still lacks the appropriate plan for fire water flow. If you look into the report, it's not, as I'm reading this in, I'll comment. Again, I was told by Karen in an email that this was all set in March, also not true. I'm sorry, but there seems to be a theme here, and it is rather frustrating that it takes us requesting this information since March to find out that you're not being transparent with the citizens of the community. I feel there is an obvious bias happening here. So as we comment on the fire, it still says that the water for the fire system still needs to be done by the developer and is not on that report as being adequate to this point. Please, Mr. Jenks.
I don't know a lot about these water pressure systems, but we may be confusing pumps with pumps. I think the Boland Station and the other that I can't think of the name of is used to supply
Hosmer Station.
water towers, Hosmer Station, used to supply the water towers. The pumps that I suspect are referenced in that report are individual residence pumps. So if DPW is saying we don't use pumps or we don't allow pumps, I think they're probably talking smaller individual pumps, and that may be because of a control situation if you get a lot of those in the system, I'm guessing. But I think of the two, and I think there are only two, pumping stations. They probably pump up into the tanks.
Right.
And of course, then the pressure is a function of gravity and height above.
Sure. So as you look at that report, the developer would be installing pumps to offset the low water pressure that needs to be at least 35 PSI. So he's installing on the property, pumping 4 PSI within the buildings.
I haven't looked at the report, so I don't know what he's talking about. I do think that I remember there has been discussion with him providing, him being the developer of Park Central, providing space for a new water tank somewhere on that property.
That is correct, but not any of the infrastructure such as the water tower itself. Land for the water tower, but not the infrastructure that would be associated with having to put that up. That would be the taxpayers. Thank you.
Karen Shimkus, Limerick Road. I just wanted to call to your attention one letter that I did not read tonight, but that you've already had in your possession, and that's calling a spotlight on the fact that there's a question about the project extension deadline expiring. Project deadline extension expiring. Now, I've written a letter to all the boards, and again, you already have it, so I wasn't going to get into that tonight in addition to what I've already discussed, but Sam just made a reference to it earlier. There was a meeting of the ZBA on June 29th with a June 30th deadline listed on the ZBA agenda for that night. And that night, there was no motion made and no vote taken to extend the project extension deadline. So I'm brought on board. Of course, for it to be legal, you have to make a motion and someone, you have to take a vote. They did at the end of the meeting, and you can watch it on tape. It's right on Southborough Access Media. They did make a motion and take a vote to push the public hearing out. Okay. But separate thing, completely different dates, apples and oranges. If you look on the agenda itself, the deadline reads 6/30/18. Subsequently, there were no other public meetings or hearings. They had some cancellations. They had scheduled it and then canceled. Lo and behold, on the next agenda, magically, the date reads 8/31/16. Presto changeo. How'd that happen, right? No vote, no motion, no vote, and no further hearings. So I think, again, these are questions that have been put out there, and town council isn't here tonight, but, if we're not able to get an answer from him, I think it would benefit everyone, namely the town, us. I wonder sometimes who's looking out for the town, to get an answer to that question. I mean, we're talking about a few things that look like they've expired, and we're having these meetings, which is crazy to me, without these answers. So I'd appreciate it if someone could follow up on these deadlines, and you now have the record to refer to them. Thank you.
Is the deadline people are referring to a deadline to act within the 180-day limit that kept getting extended? Is that what it was?
They're going to have to get you copies of the agendas and the minutes.
I'm sorry, I'm not looking beyond it. I'm looking at Sam because I figured you'd know the answer. I'm sorry.
We'll get you copies of the agenda and the minutes, and then if you compare that to the tapes, you'll be able to see for yourself.
Yeah.
Thank you.
Mm-hmm. Based on the plan at the time.
Dave Schwartz, 55 Flag Road. And Judith, I will make a copy of this letter and give it to the group. And what I wrote earlier, I just read in my own words, so you're welcome to, this is for you to review. So to the point of the discussion of Park Central draft EIR, as opposed to the legal opinion, which has been addressed, I want to go to the DEIR. I'll read this in. A discussion of the Park Central draft environmental impact report can only begin with a discussion of the January 25th EENF for Park Central as authorized by Epsilon on behalf of the Capital Group and entered by MIPA on January 30th, 2016 for which a certificate of the Secretary of Energy and Environmental Affairs on the expanded environmental notification form is based, and as was approved on February 26th by Secretary Beaton. So the whole, how we got to now, I always ask, here we are today, how did we get to now? We got to now because there was an approval of a certificate from the Secretary to proceed with the further development of the project. In that EENF, the capital group, which I call herein the proponent, stated as its basis for the access configurations for the site in reference to the scoped interchanges, all of which were listed and represented the scope on mark, in quotes, the study area being acceptable and adequate in assessing the impact of the project on the surrounding roadway network. So the Secretary, through his own advisors, agreed that all the intersections that had been identified and listed were within scope, and no one's objecting to that. The proponent indicates, quote unquote, and this is in the Secretary's words, Secretary Beaton, that the study area intersections, as above study area, experience crash rates that are lower than the MassDOT statewide and district-wide averages. So it was on this basis, as well as a basis that specifically stated there were no trends in traffic, using a traffic simulation which was built by and paid for by the developer, and which does not incorporate a number of factors. So it was on this basis, how we got to now, the assertion by the proponent that MassDOT did not require, i.e. waived, what they typically require as a roadway safety audit and specific safety-related mitigation at any location. The Secretary waived that based on data that they submitted on the traffic simulation, which is completely flawed. The TIA included, as stated on page 6 of the EENF certificate, that it included a summary of all the existing traffic conditions within the study area, including traffic volumes, intersection operations, levels of service, volume to capacity ratios, 95th percentile queue lengths for signalized and unsignalized intersections, crash data, pedestrian bicycle accommodations, and public transportation services. That says absolutely nothing, okay? Because the actual queue lengths that I've computed represent in excess of a mile of traffic that will flow through that intersection, and none of this information is represented in a way that's comprehensively interpretable. It would be amazing if, as a town, we have a conservation committee, we have a recreation committee, we have a planning board. We don't have a traffic committee. And it almost seems like this house of cards is hinged on a single idea that the traffic study that they did to start this ball rolling down the hill was accurate. So the movement, me, David Schwartz, in this case, has provided a notarized signed affidavit as an engineer with a master's degree in electrical engineering. I was asked by Mr. Eagle what my certification is. My initials are on this crash study report that pulls the MassDOT data from the MassDOT database, which is in direct refutes and rebuts the data that was in the crash analysis at this initial EIR, which was used by Secretary Beaton on February 26th. And further, I have a degree in system simulation and computer science with dual advisors in electrical engineering and urban studies, and I am basing my interpretation of this study on those credentials. Number one, it did not incorporate MassDOT accident data correctly, showing no trends, where I allege that the MassDOT data, which is actually accountable from 2011 to 2014, has a 6 times accident incident relative to the flag Route 9 compared to 495 North Route 9. That their study did not incorporate an interweave model for the access to Cumberland Farms driveway, which is less than 4 car lengths from the flag Route 9 interchange. They did not model the traffic entrance exit through flag as the exclusive egress after the negotiated settlement with 6 abutters, but not with any other parts of the neighborhood. And they really used the terms very loosely in their recording of their legal agreement, as if the neighborhood has agreed to whatever it is that these 6 abutters might have agreed to, which would necessitate a queuing calibration which incorporates the distance to a T intersection with no signalization, or if with signalization, then with signalization. They did not incorporate bus routes, which comprise on the order of 100 both-way stops in an interval from 6:30 a.m. to 8:30 a.m. on Flag Road and the feeder roads. And if I could mount the map, I have a complete map of the bus routes and all of the stops, and it goes to the whole point of not only the scenic road, but the turn left, completely out of alignment with any traffic study, because the model simply didn't incorporate any bus data. They did not incorporate the modeling of Flag Road and the connector roads, which has over a dozen immutable blind spots caused by either S-curves or by grade changes into their calibration. They're K-factors. Totally just like it's a straight road, 37 miles per hour, all's good. You know, everybody's driving, 8 miles, 6 miles or 7 miles more than the current speed limit. We'll use that in the calculations. It's not the way you run a model like that. They did not incorporate the additional trips which would result from the development of the future site in any kind of context in which it could be identified, because they specifically defer to say what the future site will be. It's 9 acres. How can they have data that incorporates the future site when they're absolutely not identifying what the future site is? And there's real ambiguity about whether the backflow from Red Roof Inn, Park Central, or Cumberland Farms back out has been accounted for. And my last point on this is it fails to identify the split egress with parameters in a manner that would represent the impact on queues if in fact there were no left turn, as a compliance requirement stated in the 495 Route 9 Interchange Improvement Study due to the rural nature of Flag and its feeder roads. That in fact, as having agreed with the abutters not to use Bantry, Tara, Blackthorn for any kind of egress from this site, they simply spill all their traffic through the John Boland Road, and in no way under any model have they represented just a right turn only, which is a requirement. And if they did that, it would show that there would be a backup of traffic of over a mile at that intersection people would not be able to get out of their homes. In fact, the modification of the plan to incorporate entrance and egress from both flag roads, which achieve the waived roadway safety audit or specific safety-related mitigation at any location, is based on these false data in the initial EENF. Further, MDOT specifically required that the proponent consult with MDOT in the February 26th letter from Secretary Beaton to modify Flag Road, Route 9, in order to maximize the distance between the intersection and the I-495 northbound exit, and a further signalization mitigation narrative based on a proper signal warrant analysis was required. The proponent has not maximized the distance of Flag 9 from 495 in any way, and based on the interweave rejection for PCD to 495 North, based on the statutory regulations for safety, the F9 to Cumberland Farms, notwithstanding F9 to 495, do not meet the safety regulations under the current plan. Basically, by straightening that intersection, they haven't added more than one car length of additional distance between Flag 9 and 495 North. So they haven't mediated it in any way whatsoever. This point is made as a corollary point insofar as the actual allowance of egress in both directions is traversed on the original sin of the misrepresentation of data by the proponent's consultant, Epsilon Group, which allowed the certificate to be released at all. You know, there are three kinds of lies: the basic, simple lie, the damn lie, and statistics, okay? And I'm going to tell you straight out, this is absolutely not going to happen under our watch. There's no way that this is going to be allowed to happen because this is a completely fabricated study. The movement allege, therefore, that in spite of the constructive effort of the proponent to provide a DEIR, has breached the ethical basis for the traffic component of the original submission and requests that the variances which are predicated on the permission of the EENF be held up and not approved. And you asked why we hadn't appealed it. Well, nobody got notice that these had, I didn't get notice. The first thing I would have done would have been to appeal this, okay, on the basis of this information, which has been submitted and which has been on file. Further, the movement respectively requests that no permitting of this development project be permitted, which incorporates any egress from John Boland Road onto Flag in either direction, unless and until a proper traffic analysis that represents all the factors in a simulation deem either that this is actually safe, according to statutory requirements for highway permitting, or that another access configuration is provided which meets the traffic and statutory safety requirements.
Mr. Schwartz. Mr. Schwartz.
Yes.
I might have missed this. That document you just read, have you sent that? Who did you send that to?
I prepared this afternoon in response to the agenda that you posted, Don, and as I said when we entered, I'm going to provide this letter. I want to fix a couple of typos, but I'm going to give you this letter in the morning as my input from this meeting, if that's acceptable to you.
I'm not sure if the planning would gladly receive that, but it would seem to be not our action item to do that. It would be more to the ZBA.
I'm going to give it to Karen Finelli. The point was that the agenda said review of the draft DIR, and my original premise is a discussion of that can only begin with a discussion of the falsified January 25th EENF. And I don't know when to say that, so I'm saying it now, and I accept the fact that this isn't. I also made a statement about the legal implications I felt give you the powers to have equal authority in any approval of a comprehensive site plan because of the intertwine of the 40A and 40B. I mean, they're completely intertwined. So there's absolutely no way that you're not, you know, in my opinion, again, I'm stating that for the record because I think it needs to be reviewed by town council.
Well, that's really one of the reasons that we put this on the agenda.
I know, and
It was to allow a full, I guess, forum for comments like yours.
Fair enough, and I appreciate the opportunity. And again, I apologize if I'm being a little aggressive, but I feel like I've been left, the train left the station, and I was dealing with, you know, a sick brother for who I was getting, you know, guardianship through the last 7 months. I got no notices, and now, you know, I'm trying to put in what I hope are, you know, constructive comments and supportive of the position of the residents in town and the Flag Road residents. Thank you.
Thank you. Tom, did you want to speak?
Hi, I'm Tom Gittens. I live at 73 Flag Road. I want to start off by thanking you all for sitting through not 3 meetings, but 300 meetings on this topic. I also want to thank all you neighbors. I'm embarrassed, frankly. I've been coming to these meetings for a really long time, years and years and years and years. But I've been lazy, I guess, because the things that you guys have revealed, I never knew about. So thank you all very much. And I haven't necessarily always seen eye to eye with you on every topic, but I just want to express my appreciation. I'd, of course, rather that the project not happen. That would be my first choice. I live right on Flag Road, pretty close to where this is. I would also advocate no changes to Flag Road. I mean, it's a nice little road. I'm against the idea of them doing a left turn if we have to let them come out onto the road at all. I'm not really for sidewalks, and as part of what you all do, I know we're coming towards the end, so I'm just going to kind of touch on the points that I've made to you in the past. I would also say that I was at the ZBA meeting on Monday or Tuesday, whichever day this week. and I was surprised that Mr. Catanzaro seemed to open the door to no left turn onto Flag Road. I'm not sure whether people caught that or not, but I was surprised that that seemed to be the case. I have heard members of this board on many occasions express concern about traffic on Flag Road and about taking actions that might mitigate and or eliminate and or one way or another oppose this project spilling out onto Flag Road. And I wanted to just stand up and first of all, thank you for that and encourage you to follow that as whatever actions you're legally allowed to take to create barriers to it all moving forward. I also want you to know, and I'm sure you do, but I want to express my appreciation that you apply your best judgment as you go forward with this across a bunch of areas, because it's a great big project with all kinds of things. I read the DEIR, I think it's called today, for the first time, and it raised a couple of questions for me that are personal to me, and this is me being really selfish for my property. Number one, I'd like to make sure that no gas trucks come out of Cumberland Farms and come down Flag Road. So I don't know where we make that a condition, but it just seems like that would be a terrible thing. Second, there's a place where the current plan calls for them to, if you think about the road, Boland Road, there's 3 houses in the plan that I saw in the DEIR. The third one up is on kind of a point that extends almost to my property. It looks like I'm about a foot from being in a butter. So if we could put I've been to some of these meetings in the past where they've put buffers that says you can't cut down all the trees all the way to the property line. If there's a way that we could make that happen so that, I think he's currently planning, I could show you a picture that I pulled out of the DEIR. He's planning to cut that all the way back. It'd be nice if he could just leave 10 feet of trees there.
Hold on a second, Tom.
Sure.
Does anybody have a plan that would show that triangle?
I have it right here.
No, but I mean for the TV. Can you point to that?
I think it's there, but I just,
Yeah, oh yeah, and actually, if you hold it up in front of the mic there, Tom, I think that the TV can get it. No, back over where you were. Oh, it's right here.
And again, this really only impacts myself and my next door neighbor. But, I mean, we're down in the short rows, right? So right here, there's a zig that comes right up, right behind his property and
Hold on,
like
she's
this
gonna
close
try-
to mine.
Okay, turn it a little. You see the monitor up there?
I can't.
There you go.
you're on TV.
There you go, right there. Yeah, now point to it.
No, I can't see it. It's right, it's right here.
No.
No, it's right here.
Yeah.
So it is. So if we could just not cut all the way to the edge of that, it would mitigate the impact on my property a little bit. I also read about stormwater, and what I read seemed to say that their plan is to dig a bunch of holes, and when all the water comes off, it'll all kind of go into holes of one kind or another, and some of them are holding ponds. And I'd like some kind of, I'm hoping somebody's looking out to make sure that that doesn't just end up going down into the water and raise the water table at my house so that suddenly my basement's not underwater. So I don't know how that happens or who protects us against that, but if in fact that's part of your purview, I hope that you will take that into mind, or keep that in mind. Are we allowed to ask the town planner questions? Is that within jurisdiction? I know she's new,
Doesn't matter, she's getting paid.
so that's a yes?
Yes, and I'll
I'm
try
just
and
curious
answer
if
them.
you have an opinion about safety on Flag Road, being relatively new to our town.
It definitely is an issue. We've been talking about it a lot. I do not know all the issues yet. I'm trying. I've only been here 3 weeks. But it definitely is a concern. That's what part of the report that we sent from the planning board as well. That's as best as I can answer. That's when I found out the report about the no left turn on the MassDOT website.
And then my final question is, I guess to you, Mr. Morris, just I know you guys have been listening to this for a really long time, and at some point you make some recommendation to who, and when is that? And I was just wondering if you could just give us a little, and maybe I had to run out and pick my daughter up, so if I missed you talking about that earlier this evening, I apologize for that. Thank you.
Mr. Jenks.
Gee, thanks. Given the fact that this project is an amalgamation of several different sites, including a future site on which we're told they're planning a hotel and a nursing facility of some sort. And it's a mixture of a Chapter 40B comprehensive permit affordable housing with what we think ought to be a 40A project. If it were just a 40B comprehensive permit project, very clearly we would be advising the zoning board. And the zoning board, as you heard earlier, they essentially can stand in for any other board in town. So they can stand in for the planning board. There is a limitation. They stand in for the planning board to do anything that the planning board can do. They can't make up, although I'm not sure they know this, they can't make up additional things that the planning board couldn't do anyway. It is to the extent that they can order the planning board to issue a permit. And it's other boards. I'm just talking because we are the planning board. And I think I'm correct that if we refuse to issue a permit, they would just issue it on our behalf. So that's one piece of it, and that's clearly reporting to the zoning board. From the developer's perspective and the zoning board's perspective, they want to mold the townhouses in with the 40B project under the terminology of an integrated site development. And it's their belief they can regulate that as though it were a large Chapter 40B. In my mind, that issue has not been settled. But I'm not sure I could tell you where that's going. I mean, the time is running out on this. So we have jurisdiction for a mini site plan? Yeah, I don't like residual. It's a residual. It's really, the right word would be a modified site plan, covering the 4 areas you're very familiar with. So for that, I guess we don't make a recommendation to anybody. We either ultimately reject something or approve something within the realm of those 4 issues. If it were a standard 40A project, typical subdivision, for instance, we would just be the approving agency. In this whole process, our role is to negotiate with the developer. I'll speak my own limited experience with this developer. I think we've successfully negotiated things with him before. But it isn't a case of where we report to a single person. The state regulations aren't even set up that way. Our town regulations are not set up that way. We don't meet with the zoning board at the beginning of a project and negotiate what they're gonna do and what we're gonna do. The regulations are all very clear. It isn't a mystery. What's made this a mystery is the terms in the use variance. Their own attorney on more than one occasion has said, hey, if you didn't like it, you should have appealed it. In my mind, it's not that easy. Who wants a battle between a planning board and a zoning board in their town? I mean, there's unlikely to be any winner. There's going to be great expense. Our hope was we would be able to negotiate things. It may be there are certain things that we're just going to do in spite of what the use variance says. But there isn't a provision anywhere in the regulations for one person who oversees the whole thing. It's not like industry or a business. But the rules are there. They're all in writing. It's a matter of trying to get everybody to follow them.
Okay, and then I'm sorry, again, I was away. So am I allowed to ask a question of the consultant? So my question to you, and I'm not sure exactly of your expertise.
I'm a planner.
I'm getting 73 Flag Road. I heard somebody say at the ZBA meeting that he could have come in for 500 low-income houses, and the state would have just approved that under 40B.
Lord.
So I'm taking that as probably that wouldn't be true. Thank you.
First of all, he could only apply for a certain number of units at one time anyway, because there's this concept called the large-scale project cap. And I don't have the regs in front of me, but I imagine you're probably 250 units. I think that is probably the large-scale project cap. I can't talk tonight. So there's a limit on how many units he can apply for, or any developer can apply for at one time. Now, they can come back and apply later, but you have a state-approved housing plan here, so there would have been some reprieve under that anyway. If a developer applied for and received a comprehensive permit for 250 units, there would have been some reprieve. But first of all, the state doesn't issue the permit. The Board of Appeals issues the permit. And once you're over 10%, then there is no obligation for the Board of Appeals to grant any more permits. They can, but there's no obligation to.
So we could just say as a town, we only need 40. Sorry. We could just say as a town, we only need 45, so you can put 45 on this lot.
Well, not
and that's it.
exactly, no, because if you were 45 units from being at 10%, you can't tell a developer you can only apply for 45 units, because the issue is still, what does it take to make a project economic? So the burden is to sort of demonstrate that if they actually proposed a project that really needed 200 units, then the 45 is irrelevant. But then again, you end up well over 10%. So there's this trade-off, but
Thank you.
no problem.
To that point, very good point, by the way, that's been part of the frustration from the get-go, is you have our ZBA chair, Mr. Bartolini, making hyperbolic statements like that, saying, oh, we could do, X number 100 of units, and it would be approved tomorrow by Mass Housing. It's ridiculous and not true.
The subsidizing agency role is to review the project prior to it coming to the Board of Appeals. And then, if the Board of Appeals grants a comprehensive permit, eventually the subsidizing agency has another role, which is this thing called final approval. But they're not issuing the comprehensive permit. Now, arguably, they are issuing a document called a project eligibility letter, without which the developer can't ever get in front of the Board of Appeals. So they have an important role, but they're not the permitting authority. The permitting authority is clearly with the Board of Appeals.
That PEL, though, often is done on a kind of preliminary basis without the initial precursor requirement boxes being checked, and one of those is safety. So that did not happen in this instance.
PEL, they're not sitting in the role of the Board of Appeals. They assume that the Board of Appeals will review safety. There are very specific criteria for a project eligibility letter. The subsidizing agency is not looking at the plan review matters that will come to the Board of Appeals. They're looking at, does the applicant have site control? Is the applicant an eligible entity? Is the site generally appropriate for the kind of housing that's proposed? They're very broad criteria. They don't look at safety.
Right.
That's not their role.
But in addition to those criteria, a concern about those initial criteria even being checked. Who verified them? I can
can't
tell you
answer
there's
that.
discrepancies.
Is
Right.
the subsidizing agency Mass Housing in this case?
It
Does
is.
anybody know?
I would like to leave you with a thought here, and then I have to go home to my husband, who was digging dinner out of the fridge for himself tonight. But Mr. Jenks made a comment about who wants a battle between the planning board and the ZBA, and I'd like to reframe that a little bit, or have you think about things a little bit differently. Who is looking out for us? It's not about you. It's not about the ZBA, okay? It's not about, who wants a battle between the two of you. Nobody wants a battle.
I meant that as town-wide. I didn't mean it as the boards.
But
Well, the boards don't either, but it's everybody who would end up paying for that.
You know what? We're going to end up suing ourselves. How ridiculous is that? Because normally it's the town who would deny the comprehensive permit. So instead, if we choose to appeal, we're suing ourselves, basically. How ridiculous is that? But I can tell you, it's not going away, folks. So if we're going to the mat, we're going to the mat. But, in terms of a battle between planning board and ZBA, from day one, it has been very troubling, concerning to me, the entire process. I would pick up documents like, for instance, the use variance and know immediately something was wrong. And yeah, right? Know immediately. Now, who has the skill set on ZBA that picks up a document and knows something's wrong? Instead, we've gotten this completely, really biased feedback night after night after night. Just every comment really in favor of the developer. And it seems like almost no one's read the DEIR. It's just amazing. But again, to reframe that question, I'd like to leave you with the swing thought here. My husband's a golfer, swing thought. Who's looking out for the residents of this town? Our most vulnerable citizens. If you've ever taken the time to understand who lives at the end of Flag Road, right at the main access point, do you know who lives there? Does anybody even know? I've gone and I've talked to every one of them, okay? Every single household has either a toddler in it. I went up to Dad with 2 kids playing in the mud on a hot summer day with a hose, the typical kind of stuff, right at the entrance. Right at the entrance. Virtually every house has either 1 or 2 or 3 small children, toddlers. A woman, how about this? A 4-generation family, grandmother, mother-in-law, father-in-law, son and daughter, and a toddler in the same house, right at the entrance. And the up gradient so far in terms of a driveway, how could that ever be safe? This is irremediable. You have options here. It's called, approve, deny, but irremediable. Some of this you can't fix, and that's why you would deny. Senior citizens. seniors, I'm not talking like senior, I'm talking seniors, who have mentally disabled adults living in the home. Did you know that? Did you bother to go find out who lives there?
I think Mrs. Shimkus, we appreciate your efforts, but I think we're getting a little bit off.
You know, there's a human element, this is the point, okay, that isn't in the traffic studies, and that isn't in the DEIR. But if you understood who lives precisely at the proposed access points, whether they were entitled to the access points or not, you know, at one, there was, you know, a family, again, multi-generational with a severely autistic kid, okay? Severely autistic kid, right at a...
Who walks every day on the road with his father. Yeah. He walks every day on the road. I mean, these are the human people.
Yeah, and again, I mean, the developer, you need to hear this. The developer goes into their, or gets a hold of them, tells them they want 20 feet of their land. The guy's got 100 acres, and he tells this woman, the grandmother, he needs 20 feet of her land. She said, you know what? My husband passed away.
Again, I want to
But I know what he would say.
I wanna
Anyway, I'll leave you with that thought. Thank you.
Okay, thank you very much. Yeah, sure. We're approaching a little over 2 hours, so yeah, we'll keep going, but think about wrapping it up. We have more items on our agenda.
I realize it's getting late, but I'd just like to ask Judith one thing. You've
You
heard,
can call me Judy.
oh, Judy.
Only
sorry.
my mother called me Judith.
Oh,
It's all
I
right.
don't want to be your mother. So your first time here, your first time listening to the citizens' concerns about Park Central, the planning board. What is your recommendation at this point in time, if you're able to give one? Because I think this is just going to keep going on and on and on.
Okay, I'll tell you what I think.
Thank you,
First of all,
thank
I
you.
think there are some comments that need to be made on this draft comprehensive permit decision that I'm going to give to the planning board. I mean, there's some things in it that really are not consistent with current state regulations that probably wouldn't interest you guys, but I just know there's going to be a problem with this later on. So there needs to be some discussion about that. But frankly, you know, what I think needs to happen here is there needs to be a work session meeting. Assuming the public hearing is still open in a valid way, and I'm not commenting on that because I wasn't at the Board of Appeals meeting. I don't know what vote was taken. I'm not going there. But there needs to be some kind of work session here with someone from the planning board, someone from the Board of Appeals, and town council. And if you want me involved, I'll help. But people need to work together on this. I mean, your point is so well taken. There is this kind of confusing jurisdiction here. This town has plenty of smart people in it. I don't think this is an unfixable problem, but there's got to be some kind of work session before they close the public hearing, in my opinion. That would be my comment. I have a number of questions about this, not the least of which is the legal status of that variance. I just think there's some questions Aldo's going to have to answer, but that's a very significant issue, is that variance is over a year old, and I'm not aware of any authority under Chapter 40B to just extend a variance. I'm not an attorney, but I think it's a very important question to ask town council.
I appreciate that.
Pardon me?
That's a 40A.
It's a 40A variance under Section 10 of Chapter 40A. So, you know, I don't see any authority under Chapter 40B to extend automatically a variance that's granted under 40A. I just don't see that. But again, I'm not an attorney. I just think that there needs to be a work session. This is a huge project. The town will probably never see a project this big again. And, you know, I mean, it could be a good thing for your community. I'm not commenting on you know, the impact on you folks, but, you know, your goal with a 40B is to get the best project you can for your town and for the neighborhood that's going to receive the new neighbors. And I don't know if that conversation's happened here, but it just sounds to me like it hasn't. So, you know, I don't want to, like I said, I don't want to cast aspersions on the Board of Appeals. I wasn't involved, but I think that conversation needs to happen. You have, like every other small town in Massachusetts, a decentralized government here. You have boards that operate in different domains. That's a choice that your community made. There's nothing wrong with that choice, but now you have this big project that requires coordination, and you don't have the the political infrastructure to make that happen. So people are going to have to be adults and figure out how to do it.
And in terms of who is the adult to initiate this recommendation, if people are so inclined to take it into their hands?
I don't know right now.
Is this a town council thing by any chance? A legal counsel? I don't know. But to just reiterate what you were saying, when I was at the ZBA meeting and I asked the board with regard to the futures on that land, it was said to me, and I don't want to quote anyone, that we're just talking about the 40B. And I like to think futures and think out of the box. And I don't think what's happening right now here in this is thinking out of the box. That when you approve one thing, it's going to lead down the road to the other. It is a project. It has phases. And people, I think, are looking at what I call a Band-Aid approach, a quick fix. This is not a quick, it should not be a quick fix. And I'm going to depart tonight on that note, so thank you.
Sorry, I've been trying to get up here and just make a quick comment, because Mr. Regal, the new chairman of the ZBA, actually brought up the other night, is that, well, one, the developer had mentioned that he was all set with the planning board. So just so you know that. That everything was okay, he put in some pocket parks and we should be good. Which are smaller than an actual single unit, but that's besides the point. The other thing is we never brought up is the noise from clear cutting the entire property all the way up to 495, for the most part, right? I mean, the density of this project alone is just way over the top. The developer felt the need to clear cut all the way up to the lines of the abutters. There were 5 abutters that he says he has a landscape plan with, so Mr. Eagle actually had referred to that as, well, we already talked about landscape. What he doesn't realize is that he talked about landscape with 5 neighbors, right? Not with all of the people that will be impacted by this, so it was a good point that you made. Well, no, not so much the lights, but clear cutting all the way up to your property. You know, one of my neighbors across the street will probably have, you know, 6, I'd have to measure it, but 6 or 7 units that are the same size of his house on about the same acreage, right? I mean, it's way over the top. And is there a reason on a 100-acre piece that you need to clear cut all the way to somebody's lot line, taking down 100-foot trees to replace them with 6 to 8-foot bushes that will grow a foot a year, right? It just seems completely disgusting to me that needs to happen that way. So I know that one of the areas that the planning board actually has authority on would be landscaping. I think that you have authority on all of it, but that's my opinion, and I hope that you're gonna do that full site plan review, so, you know, if it does come to an after-the-fact issue or comments that we're gonna have to make through a legal process, that we have that. But just wanted to bring up that point around the landscape and how Mr. Eagle feels as though it's all set, and I don't think any of us feel that way. Another thing about Flag Road is the culvert. Nobody's addressed the culvert. There's a culvert, Judy, just for your knowledge. It's about 50, I've seen conflicting reports of it being anywhere from 15 to 16 and a half feet wide. It's a 2-lane culvert. The traffic will back up. I mean, according to the current report, it will back up in the morning and at night.
Sure it will.
And yeah, right. And you'll have to have 2-way access, right? But what the response to my question about it is that it's actually, it will be a traffic calming measure. So they don't have to address the fact that you can't fit a bus in a fire truck at the same time through the thing, right? So if one of them's parked there trying to get out, and there's a car behind it, and there's a car in front of it, and there's an emergency, there's nothing you can do, right? It just doesn't work. The road doesn't work, but it's another thing that we need to be aware of. The response that I got from, I forget the name of the traffic report now, because it's changed names a couple of times, but was that it will actually act as a calming device, which is kind of strange. Thank you.
75 Flat Road, Yan Huang. I guess the first comments I just got stuff I heard for tonight. I have received some sort of a mail early. I think I am an abutter, And I have received some certified mail early on, but things dropped off a while, and I am not in any agreement with the developer or anything. I have not been involved in a lot of the stuff that mentioned here. So I just like to state that and reinforce that, so that it's not true that the developer is in agreement with all the neighbors. So I'm here for originally just because of the DEIR. Some things I've read there concern me. And the jurisdiction of who has jurisdiction of flat road is of great interest to me because it identifies 2 places where mitigation is required to meet the minimum intersection distance. So that is a great safety concern for me there. Thank you.
Mrs. Shimkus.
Sorry, I just have one closing comment, which is,
Quickly.
it's just a footnote. But this, is, to me, is not a matter of being adult, about coming to some kind of conclusion or agreement. It is a matter, because we're all adults, and we've all read the 1,000-page reports. You know, I've have a professional career of 25 years evaluating commercial real estate sites, large scale. So it's not a matter of being an adult, it's about a matter of professional judgment as to locational attributes and whether or not this really is the best location for a 40B. I think, you know, all the hearings that we've been to up to now, I mean, there's a difference between doing 40B consulting and advocating for a 40B and getting that 40B through and being paid to get a 40B through. And objectively, a whole different world, commercial real estate. And, you know, looking at a quadrant, in this case, it's the northeast quadrant of 495, which is completely different from the other 3 quadrants, which have miles of feeder roads, completely different, which is why it hasn't been developed up to now. So that's, these types of things, these professional observations, are what you will not hear from a 40B consultant. It's important to look at access, safety, roadways, all the things that we've talked about tonight. So there is a difference, and I would just caution you to think about that. Thank you.
Before I call on Mr. Mills, Judy, did you have any more to say? Did you find this to be
Enlightening?
informative?
Yes.
Not just for yourself, but did you get the feeling after millions of these meetings that you've been to in other towns that there was some benefit to this tonight?
Well, it's educational for me if I'm going to try to help you. I'm not sure, and if I were sitting out there, that I'd feel all that, you know, like I've benefited from this. But if I'm going to try to help you, yeah, it's been helpful to me. I mean, I've learned some things plural, many plural, at this meeting. So
I'll ask the rest of the board if anyone has any other comments. Mrs. Luttrell.
The question of the status of the use variance, in my mind, I would think that's the first thing that needs to be resolved, because everything else is, if that's not there anymore, the whole project is changed. So do we ask town council that question?
yes, I would strongly recommend that you ask town council that question.
Well, as I read earlier tonight, he sent us that note saying he'd be fully available from 5:30 on Monday, so maybe at that, in that
That question
session,
needs to be asked.
we would, and of course, between now and then, hopefully town council would have a chance to watch the video and gain the benefit of some of the questions or concerns from the public that were brought up, and there were several.
May I ask just a question? When the original comprehensive permit came in for home ownership development, it was how many units? 180. So, no, the original comprehensive permit application, before he agreed to. So Mass Housing issued a project eligibility letter for 180 units, 25% of which would have been affordable. Yes?
Yeah.
Okay.
He threatened 580.
Well, just so everybody understands, your town has an approved housing plan. And if the board of Appeals granted a comprehensive permit for a homeownership development of 180 units that had at least 37, 34 lower moderate income units in it. The Board of Appeals would not have had to grant a comprehensive permit for at least 2 years. So I don't know where 500 odd units is coming from, but you have an approved housing plan, and under that, if you work toward your 10% in a systematic way, then the Board of Appeals, or the town can request that DHCD certify that plan, and if DHCD does so, then the Board of Appeals can essentially stay the granting of any other comprehensive permits for a couple of years. Your town looks to me like you're about 58 units shy of the 10% statutory minimum. So I don't know where this 500 number is coming from, but
If I remember correctly,
yeah,
the original application for the comprehensive permit predated by hours or days the submission of the town's affordable housing plan. So,
you were eligible for certification for a previous project, I believe. You can submit a housing plan while a comprehensive permit is underway. And you have to act on that comprehensive permit because you don't have safe harbor. But if they granted, I'm just saying that if they granted a comprehensive permit for 180 units, the housing plan's been approved, and that comprehensive permit has at least 34 low and moderate income units in it, then the Board of Appeals is eligible to deny a comprehensive permit for at least 2 years, you know, assuming the town actually, you know, gets their plan certified. You know, they can, once the Board of Appeals grants those units, then the town is eligible for certification, and then the board has a chance to sort of stay the application. So this may still have been approved as 180 units. I'm not saying that he was not eligible to apply. I'm just saying that when people start hearing about 500 units in the state approving, you know, this massive number of units, that's just not the way it works. I mean, I have to take issue with what you said. I am a Chapter 40B consultant, and I'm a planner, and I do care about things like, you know, intruding this much housing in an area where, you know, I question whether it's an appropriate location too. Unfortunately, whether people like it or not, the decision-making power about whether a site is appropriate lies with the subsidizing agency. That decision was, that authority was clearly established in a decision involving the town of Amesbury a couple of years ago. That's the way it is. So once that decision is made, what you really need to do is to try to get the best project you can for your town that also respects the neighborhood. Because you're not going to win a fight. I'm sorry, you're not going to win a fight on the suitability of the site because the state has already said it's suitable. So now what you have to do is try to get the best thing you can. And I understand that you disagree, but unfortunately this is, there's case law that the subsidizing agency is the one with jurisdiction over site approval. The Board of Appeals does not have that authority. So I'm not going to debate that with you. This is my field. That said, I just want people to understand that if you had a 180-unit comprehensive permit development with at least 34 low and moderate income units, which this one had to have in order to qualify, then the Board of Appeals could have granted the permit and received a stay of up to 2 years to act on any others. You were only 58 units away from the 10% statutory minimum. So these, don't succumb to threats about 500 units or whatever. That's just silly. It's just silly for towns to do this.
Thank you. Were you all done, Mrs. Luttrell?
Yes.
Mr. Stein?
I have no questions at this time.
Mr. Jenks?
No questions?
Mr. Mills?
No, I just wanted to state that, I mean, I think for not having, you know, having this tonight to hear everything, I think we're showing you that we do care, and we are taking the extra steps. We've taken extra steps by having Judy here. So, you know, to think that we don't care is a little insulting. So, that's just my personal opinion.
But it has to make sense. It has to, you can't have.
We're,
Understand,
Mr. Mills has the floor,
we
please.
don't even have a final plan yet. But we're taking the steps so that we're prepared
for when we have that plan, so we can take appropriate action. I hope everyone sees that, is my point. Thank you.
You need a microphone.
Actually, I want to move on to the next agenda item. We've been on this for, over almost 3 hours, so, Mr. Mills.
Thank you,
Motion for a
thank you
2-minute
for the
recess.
time, but it's not meant to be insulting in any way. This is
I
business.
don't want to end it this way,
Yeah.
Mrs. Shimkus. Why don't we just...
But thank you so much for tonight, because we
Thank
do
you.
appreciate it.
Okay,
Thank you.
thank you. Motion's been made for a 2-minute recess and seconded. Any discussion? Mr. Jenks? No discussion. All in favor? See you in 2 minutes.
Voting early.
Planning Board is back in session from its 2-minute recess. Next item on the agenda is discussion, revision to solar bylaw rules and regulations. Mr. Stein.
So, Mr. Chairman, how we got to this point was at the 2016 April town meeting, we passed a overlay district for as of right commercial solar installations, 250 kilowatt or greater output. The purpose of this was part of the overall green communities effort on the part of the town. And as a result of passing the overlay district, that's a new section of the bylaw, which of course in turn requires a new set of rules and regulations for this overlay district. It was a fairly smooth and straightforward process to create these rules and regulations because, of course, at the previous year's town meeting, we had passed a new bylaw restricting commercial-grade solar arrays to the industrial and the industrial park districts, and the rules and regulations for that bylaw are for the most part applicable to this new bylaw. Of course, the key difference being, since it's as of right, there is no need for a special permit. It is a site plan review by the planning board, not an application for a special permit. So, Mimi Luttrell and I formed a working group, as voted on by the planning board, to essentially adapt the previous year's ratified rules and regulations to this new solar overlay district. And we did so essentially striking any reference to application for special permit and other appropriate adjustments. We then submitted our corrections or the new version to Hillary, who submitted them to Town Council for his review. Town Council's recommended changes are in red on the version that's in our packets. And they're fairly de minimis in nature. I think they're limited to page 1 and 5 in terms of making it rules and regulations at the top and in the body of the title, and making some legal corrections to the reference of the portion of the town code that it pertains to. So, our hope with tonight's agenda item is that we could have a discussion of these new rules and regulations pursuant to a required public hearing, which I would also recommend that the planning board schedules at the appropriate time so that we are in full compliance and meet all the requirements.
Excellent. Did you have a date in mind, in September, October?
I did discuss that with Hillary. There is a requirement in terms of the amount of time needed to advertise and promote the public hearing. So I believe it was for a late September meeting, but I don't have that date in front of me right now, but Hillary has it. So do you have the dates, Mr. Chairman, for the next few town meetings? Not town meetings, planning board meetings.
I have the September meetings, the 19th and 26th.
So I believe that Hillary and I had spoken about the 19th, but it could be the 26th.
The agenda for the 26th is empty. The agenda or the draft agenda for the September 19th is 7 o'clock public hearing, which is the site plan review for 255 Turnpike Road. That's the medical marijuana facility. And then penciled in here is 7:45 public hearing, revisions to solar bylaw rules and regs. So she did appear to think that September 19th would be okay for that public hearing. So if you're, if, I think you were saying you wanted to make a motion to have the planning board authorize advertising and setting up the public hearing for these rules and regs.
Well, it is a legitimate concern that scheduling it on the same night as the marijuana dispensary public hearing could be problematic because of the amount of time that first public hearing may take.
So you want to go to the 26th?
That would be my preference, and I just would want to make sure that that gives our planning department enough time to properly promote and advertise that the public hearing.
We talked about that earlier today, Jyoti, but that's like 5 weeks away, and I think the minimum amount of time that we need is 3 weeks. It has to-
So on that basis, I'd like to make a motion that the planning board schedule the rules and regulations for the commercial solar photovoltaic renewable energy installations application public hearing on September the 26th, 2016,
At 7 PM?
7 PM.
Why don't, and, or you want to build some flexibility into this, maybe not list the time, but leave the time of the public hearing on that day up to the town planner. And then also authorize the planning department that if other things come up unforeseen at this time, that it be bumped or moved up to the October 17th planning board meeting. Would that be all right?
Motion as, it would be all right, yes.
So the motion is to authorize the planning board's going to vote to authorize the planning department to put together the public notice and advertise and put on the agenda for either September 26th or October 17th, public hearing for the solar rules and regs.
Second.
That was your motion, Mr. Stein?
Correct.
And Mr. Mills, you second. Any discussion? All in favor? 5-0, so you were set up now to make that happen. Was that the end of that agenda item?
Yes.
Okay, next item on the agenda is the planner's report. And I'll ask the town planner to just talk briefly about this document that was submitted to the planning department today.
Yes, today, this afternoon, probably about. It's a citizen's petition to update the zoning bylaw by removing the ZBA's ability to grant use variances. And this is what they want to have before the special town meeting on October 4th.
So if that's a copy, there's 126 signatures that I looked at there, and I believe, is the town clerk still certifying those, Josie?
Yeah, they're still waiting for certified signatures, but this is the petition for now.
So it's my understanding that once the town clerk informs the selectmen that there's sufficient signatures on the citizen's petition to put this on the warrant, it then gets submitted to the planning department for us to work with the proponent in, again, drafting a public hearing notice and then scheduling a public hearing prior to the special town meeting.
Yes.
Okay. Was there anything else in the planner's report? We have the meeting, we have minutes here, but did we cover it all, Jyoti?
I believe it did, yes.
We had a
I
lot
believe it did.
of stuff that we went over.
Yeah.
Okay, anything else on anything else other than the minutes? We got the meeting minutes of July 18th, 2016. Mr. Mills.
Make a motion, we accept the meeting minutes from July 18th, 2016 as written.
I've got some,
Did you want to second that, and then under
yeah, I'll second it.
Mr. Jenks?
Line 21 has discussed the property with Police Chief Paulus, who, not whom, has requested the following. And line 23, circulating driveway counterclockwise around the building.
You got that, Destiny? Those two? Yeah.
The page 2, 68, the discussion on the DEIR and legal opinion. The legal opinion really was not related to the draft environmental impact report. The legal opinion was on 2 questions dealing with the regulation of the project, not the environmental impact report. So that's really 2 items that's all put in one here.
So the board also requested a legal opinion on town council's written,
Yeah, the wording is okay. I would just separate that second part, move it down a line and I would take it out of the bold print.
okay, so it's just a separate paragraph.
It's a
Destiny.
separate item.
So have a space, line 70 be blank, and the board, the sentence starting with the board would then be line 71. And then that last sentence, Phil, on line, what's now line 70, says the letter and then will be posted on the planning boards? So is that an extra word, that and? Okay.
Yes.
Mr. Jenks?
Down on 84, he is also requesting all public records pertaining to hearings be posted earlier for residents to review and be able to comment. I think it's all future public records pertaining to hearings. I don't think the request was to go back in time and do that. So I would just say all future.
Okay, got that, Destiny?
That's it.
Motion's been made.
I have one.
Mr.
also.
Mills.
Line 28, on the first page. Board members and residents' questions and concerns were addressed. I changed addressed to discussed. I just feel that
Sure.
addressed means it,
Means settled.
that's it.
Good catch.
Anything else? Motion's been made and seconded, revisions were made. All in favor? 5-0. Meeting minutes of July 18th have been approved and will be posted. Anything else? Mrs. Luttrell?
I have a question on posting things on the website. The town council's letter was not posted on the website. And I think because town council didn't want it posted.
Which letter are you?
His opinion letter, which we promised would be posted.
We did, you're right, we stated it in the meeting that we intended to post it, and I think it was the next day, I was on the phone with town council and told him that, and he said, well, yes, it is a legal document, but he thought that it was, didn't rise itself to the level of being posted. So I passed that on to the planning department, and I never followed up to see if in fact it was posted or not.
Yeah, because my understanding was he claimed privilege, although that privilege, I believe, was waived because we discussed it in a public meeting and we promised to post it, and the client, which is us, said it was a public document that could be posted.
Actually, when we received it, it stated the 11th, July 11th?
Yes.
So it must have been the same day or the day after. I was on the phone with town council. No, actually, I was on the phone with him on the 19th because of our, I guess the day doesn't matter, but I was on the phone with him regarding the document, and obviously it was either July 11th or someday thereafter. And because Hillary had asked if it was a public document, because it didn't say confidential on it, which it usually does. And so I specifically asked him, I said, you know, is this a public document? And he said, yes. Okay. And then I think we brought it up at the meeting, and then it was asked to be posted. And then I think subsequently I told him that, you know, we're going to post it. And he asked that it not be.
Did he say
My,
why?
my feeling is that we should err on the side of transparency, especially with this project.
I think the feeling that I had was that there were copies that night, and and so it really was a public document, and the public had it, and it's pretty easy for someone else to put it on the web or on the, the blog. So I felt that unless there was additional requests to have it posted on the town website, that I'd honor the town council's request to not post it on the town's website. Mr. Stein.
Mr. Chairman, I would just recommend that copies be made available if this is discussed at a subsequent meeting and town council does come in to the planning board for a subsequent meeting on this matter, that additional copies be furnished for public distribution as requested.
And if the board wants to bring this up again on Monday, we can. But at this point, if the board feels that the letter should be posted, I'll go down the line here and do what the majority of the board wants to do. Mrs. Luttrell, already heard from you. Mrs. Luttrell.
I believe it should be posted.
Mr. Stein.
Is there some technical reason why posting this is problematic from a technology standpoint?
Not that I know of, but I'm not sure. I don't post things on the website.
Is there any logistical reason that posting this is problematic?
Not that I can think of again.
So in that case, I would agree with Mrs. Luttrell that it be posted.
Mr. Jenks?
Especially where that's going to be on the agenda for discussion Monday night, and the meeting is not an executive session. I think by all means it ought to be posted.
Mr. Mills?
Yeah, I think I'm in favor of posting it, and I'm sure you'll do this, Mr. Chairman. Just give town council a heads up that there's been further discussion and the feeling of the board, because we said we were going to do it, and in light of how involved everyone is, that it would be best if we fulfill that.
Okay. That's what we'll do. We'll take steps to get it posted. And I sense, and I'm glad of this, that there continues to be a level of respect and decorum relative to town council. Mr. Cipriano has not, has been the town council for a number of years, but my experience on the planning board has been with other town council as well, and we have a long history of honoring and respecting the town council as a person and the position. And we've also had areas along the way where we've thanked town council for his opinion, and he has fully acknowledged and guided us by saying that he only advises. And we have disagreed with town council in the past, and as a board, should feel free to disagree with this town council or any other town council in the future, all the while respecting his opinion. And I think we've done that tonight, at least I hope we have, and by having this posted, we'll simply notify him that that's what the board decided to do. Now, as far as, if that's the end of that item, I'll move on to Monday night. We have the note from Aldo that says he's willing to meet anytime after 5:30. That meeting, our meeting is posted for 7 o'clock. So, and it's too late to revise the agenda. So, I believe 2 members of the planning board can meet with town council at 5:30, either in a separate room or in public, although the meeting hasn't been posted. So I would, I guess, reach out to. Do you agree that that's what we can properly do? 2 members, Mr. Stein.
Personally, I do not agree. I think that we should have town council in for a full board.
He will be at 7 o'clock.
I will not be present that night. As I've said repeatedly, I have a conflict. I believe that was, if I'm recalling correctly, one of the motivating factors in scheduling tonight's meeting. I had long-standing conflict with Monday night in my calendar, in my one calendar. And I will not be present, and this matter is of tremendous concern to me as a planning board member, and I advocate strongly for scheduling Mr. Cipriano's appearance when we have a full board, myself included.
So is it the opinion, I mean, he intends to, town council intends to attend the continuation of the public hearing for the site plan review. And I think he's welcomed, absolutely welcomed to attend and guide us as he sees fit, or as we're able to use his advice. It's not clear if the proponent wants to continue with no action and discussion on Monday, or to continue without the revised plan and still open it up to questions and comments. And of course, if town council's here for that, we're not going to kick them out of the room. The intent of tonight's meeting, which was to go over some of these procedural questions, according to Mr. Stein, should be rescheduled for a time when the full board can attend. Get the feeling from the board on that, Mr. Mills, Mr. Stein, Mr. Jenks?
You summarized my point of view correctly, Mr. Chairman. Thank you.
So just add, while I would love to have the full board, I'm concerned with the time constraints. So I'm not, did Judy say she was gonna be here on Monday? No, she's not.
She can't.
She can't be here. So, and I'm just thinking, because I think it might be beneficial for Judy to touch base with town council with some of the concerns she might have. But don't know if, what would be the benefit of us meeting prior to, with town council on Monday without Judy?
Yes, Mimi.
To ask him about the use variance, that would be one.
But as, I think that should be done at a public meeting in front, with full board present, rather than, Andrew was just asking about 2 planning board meetings, meeting outside of a planning board meeting with town council.
Is Judy gonna have her comments ready by then, she said, right? She was gonna have a draft.
Yeah.
I would be, I would be in favor of having a meeting with town council beforehand, so he knows
On Monday.
on Monday.
Not waiting for Mr. Stein to be available.
Well, again, I think it would be prudent for 2 members to ensure that he's up to speed on discussions that happened tonight, before we meet as unfortunately not a full board, but I don't think we can. The meeting's posted, it's gonna happen, there's gonna be a lot of people here, and I think a lot of what was discussed tonight is gonna carry over into Monday. And I think out of respect for town council, for us to say FYI, make sure he's up to speed, I think that would be a prudent thing to do. Because unfortunately, Jesse, even though you can't be here, it's already posted. And he said he's gonna be here. I mean, not trying to go forward without you, but I don't think, in this case, the meeting's gonna happen, and there's gonna be discussion. So, that's my opinion.
Mrs. Luttrell.
So is the question whether to have an additional meeting with the entire board? Or is it to not have him come on Monday and have another meeting with the entire board with Aldo present?
I think there's great benefit to have town council here for the continuation of the public hearing for the site plan, regardless of any questions that we have. If it's just on the merits of the site plan, town council is usually here for that anyways, or sometimes here for those site plan hearings. So it's fully appropriate that he's here, and I think it's inappropriate that we ask him not to be here. But his offer to meet at 5:30 can only be accommodated by 2 members, because it's not a posted meeting. So the question is, does the board want to take him up on that and have 2 members meet with him at 5:30? Or have it all occur at a posted meeting with all 5 members, which is Mr. Stein's request. Mr. Mills has given us his opinion. Mr. Jenks?
Joe, he had asked for questions in writing for our follow-up questions. How many questions did we send?
I haven't sent them yet. We're going to send them tomorrow.
Okay.
I have them from 2 board members currently. And Judy's questions will not be coming until Monday.
I would think it worthwhile having the 2 board members meet with him. Take him up on the early meeting.
And we do have an agenda item saying legal opinion for 8:15, so it's already posted. So you would have to be here on the 15th.
My concern was this, as we know, is a meeting on a Thursday night, which we usually don't have, and the only reason we had it was to meet with town council. and the full board is here. And Mr. Stein made it here on a Thursday night to meet with town council, but he's not here. So I would think in respect to Mr. Stein, if he wants to meet with town council as a full board, I would agree with that.
I think we all agree with that. It's Mr. Stein's request that we don't meet separately, the two members don't meet on Monday before 7 o'clock.
He doesn't want us to meet at all.
Again, I feel that this is appropriate for a full board with a public meeting. But that's just my opinion, and I'm just one planning board member, so proceed appropriately, accordingly.
Let's, as far as the request to, on Monday, the site plan hearing will be is continued to Monday, knowing that the approval period ends on Wednesday, the 17th. The proponent's attorney has proposed continuation to the 28th, 29th, 30th, or 31st. We've ruled out the 31st because of Conservation Commission has a meeting scheduled. I believe I need to go and check with my family on my availability for the 29th and 30th, and I would recommend that you four do the same and respond back either to me or to the town planner on your availability for those 2 days, and if not, suggest days beyond that that we would be available. And we'll try to put together a date. Doesn't always have to be a Monday, but you know, the plans that were promised or that were projected to be available are not. That's beyond our control, and I think that it's appropriate for us to look at our calendars and I mean, we're making these meetings, and they're not what is promised to be. And if we're able to meet on the 29th and the 30th, fine. If not, then we just put together our dates, and we'll get back to Mr. Catanzaro with a proposed date. Is that all right? Okay, that deals with the end of the month. Now, as far as Monday, again at 5:30, we have two members that say that it's okay to meet at 5:30. Mr. Mills.
I mean, my point is, I think whether it's an official meeting or what have you, or if you just reach out to town council and let them know what happened tonight, and that Judy's gonna have some suggestions that he probably needs to be aware of before the meeting. That's my point. Whether it's two people actually meet with him, I think we should. I don't want him to feel he's getting ambushed, is my feeling. So whether or not you actually meet with him beforehand, you know, at this point, I think the more we meet with him, the better. But I just want him to know what he's coming into. That's
How
all.
much time do we have scheduled with him in the regular meeting?
8:15 and on.
We got 7 PM, that public hearing is continued, and then at 7:45, we have the bond release, so it's like 45 minutes. But We do that just, to- the 8:15, town planner and I inserted that, was that today?
Yes.
So that it would be on the agenda, and the reason it's exact same language as what was on tonight's agenda, so that we could discuss it on Monday night. And we will, and we expect town council to be there, but again, Mr. Stein won't be. And, I mean, it's posted on here at the time, at 8:15, when the posted item comes on there, the planning board, if the board decides to defer that discussion item to another date, then we'll just inform town council that we'd like to defer it. So we have 5 members. Now, Mr. Stein, you're not available until almost September, is that right?
I would be available for, let's see. If we're talking about the 29th, the 29th or the 30th, I would be available. Of August.
I have to check with my calendar at home.
I have to check with my family. I don't have a calendar. I'm retired. So, Mr. Jenks.
I'll just throw in an opinion that if we can meet before the 29th with town council to discuss his legal opinion and the additional questions that we've asked, or will have asked him tomorrow, that we should do it. With all due respect to Jesse, I don't think that should wait. I think there is important issues, and the project's going on, things are moving on. I think it's too bad that the schedule got messed up, but I think it's important that we meet with him.
Who would be the 2 members that would meet at 5:30?
I'm not as concerned about having 2 members meet with him at 5:30. That was just some extra time with him. I'm more concerned with having him come to a public meeting and meet and talk about his opinion, clarify some parts of that were confusing to people. If we don't meet with him before that, that's not a problem in my book.
So why don't we do that? We'll all just come to the town hall at 7 o'clock, do the agenda, and then if we stay on track, the 8:15 agenda item would be to discuss that with town council.
And then at least at some point, that's on recorded data that you can catch up and at least have the ability to hear what was said.
The public should probably know that the flavor or the emotions of yesterday, when we learned that there was a disconnect on the scheduling for town council. Emotions of yesterday are yesterday, and today is a little bit different, and we're moving forward. It's unfortunate, as you said, but we'll move forward the best we can with the time that we have and our availability. Anything else from the planning board? Terry?
Smile.
We still have one member of the public at 10:35. Mr. Mills,
Motion to adjourn.
Receive any more business before the meeting, or?
you all set, sir? Mr. Mills?
Motion to adjourn.
Thank you. Second.
Motion's been made and seconded. Any discussion? Hearing none, all in favor? All 5-0. Thank you.